Prayer, Lordship. Lordship may adjourn the matter for the day. I have taken consent of the petitioner's side.
26.
Yes, Lordship.
Mr.
K. Kolita.
On the prayer, Mr.
K.
What?
Kolita on behalf of the respondents.
K. Kalita, learned counsel appearing on behalf of K. Prasar, NSCGC, for the respondent. List this matter after 2 weeks.
May I please, Your Lordship? I'm back to mention item number 10, Lordship.
10.
The opposite side is also there, Lordship. So I am seeking 2 weeks time, Lordship. And the pleadings are also not completed, Lordship. Pleadings are also not completed, Lordship.
On the prayer of Mr.
J. Abbas, Lordship.
J.
Abbas, Lordship.
J.
Petitioner,
Abbas,
Lordship.
learned counsel for the petitioner. List this matter after 2 weeks.
Lordship. Deeply obliged.
Alright. May I please, your Lordship? Lordship, with the consent from other side, I beg to mention item number 34, Lordship. On behalf of Mr. Dippy Vora, Standing Counsel of Health Department, Lordship. Lordship, matter may be adjourned for 2 weeks, Lordship.
On the prayer of,
Please, your Lordship,
Yes.
As for the petitioner, Lordship, Lordship, kindly fix a date, Lordship.
what is the matter?
Lordship, matter relates to dismissal from service, Lordship.
Hmm?
Dismissal from service, Lordship.
Okay, on the prayer of Mr.
You host.
Learned counsel appearing on behalf of Standing Counsel Health Department and prayer not being objected to by MS.
Ardeka.
Ardeka learned counsel for the petitioner. List this matter after 3 weeks. Give the date on.
Much obliged.
And next date, Lordship, the record may produce, Lordship. They may produce a
see.
record. There is an order, Lordship.
If the order is there, you take care of it.
Obliged.
Lordship, I beg to mention item number 62 of supplementary list.
62.
Yes, sir. Lordship, in this matter, the petitioner counsel has filed on day before yesterday. A copy of which we have received yesterday.
Hmm.
We would like to file a reply in this.
On the prayer of
I, Bhuya, Lordship.
I
Bhuya.
Bhuya,
For respondent 2, 3, and 7, Lordship.
learned counsel appearing on behalf of. Your name is not there. Yeah, you are there. Learned counsel for respondent 2, 3, and 7. List this matter after 2 weeks so as to enable him to file objection to IA,
Yes, sir.
intellectual application.
Lordship, there is a stay on
Mr.
T. Kashyap on behalf of Mr. K. N. Chaudhary, Your Lordship.
Kashyap, learned counsel appearing on behalf of Mr. Ken Chaudhary, learned senior counsel for the applicant petitioner is applicant oblique petitioner is present. Interim order passed earlier. Shall continue.
Lordship may kindly fix a date, Your Lordship.
Let us see. Let them file first.
Lordship.
Much obliged, Your Lordship.
Lordship, with regards to item number 57 of the supplementary list, Your Lordship, I
Yeah.
have the petitioners, Your Lordship. We have obtained consent of the respondents, Your Lordship, in this matter. We seek a slight adjournment, Your Lordship. The matter may come up after a week or two.
On the prayer of Mr. T. Kashyap, learned counsel for the petition, list this matter after 2 weeks.
Much obliged.
57, huh?
Wait, please, Your Lordship, with the consent of the other side, I beg to mention item 21 of today's daily list. matter. Senior Advocate Mr. K.P. Pathak is leading the matter. However, he is unwell. Therefore,
Item
21, my lords.
21. Who is
Senior Advocate Mr. K.P. Pathak. He's leading the matter, my lord.
for
And-
petitioner?
Yes, my lord.
MS so and so, learned counsel submits that Mr. K.P. Pathak,
Yes, sir.
learned senior counsel who is leading in this matter. Learned leading counsel is unwell, therefore fresh for listing of the matter after 2 weeks.
My lord,
Prayer is
after
not,
4 weeks.
prayer not, the prayer for adjournment is not objected to by,
Arthur Malik.
prayer not being objected to by other learned state council. Prayer for adjournment is allowed, list after 3 weeks.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 56 for hearing. May Your Lordship kindly fix it on next hearing date.
56,
Yes, Your Lordship.
what is this 56?
Yes.
No, this is 2016 matter. What is the matter?
Arbitrariness, arbitrariness by the respondents to the client.
What?
Arbitrariness.
What?
arbitrariness
What? Arbitrariness of what?
by the respondent to the petitioners.
Who is
On-
petitioner? What is the case about? 2016 matter,
On disciplinary action,
huh?
there
Hmm.
was arbitrariness by the respondent.
Arbitrariness in discipline proceedings.
Yes, Your Lordship.
I don't know. When do you want?
17th of February,
Why?
on the
Why?
next hearing date.
Huh?
Because my senior,
Okay.
It is on 17 Lordship.
And then when?
First week of March, Lordship.
No, it's 2016 matter.
Last week of February.
Make it somewhere after 26 February, huh?
Lordship,
On the prayer of, on the joint prayer of learned council for the parties, let this matter be listed on 26
Your
for
Lordship,
hearing,
can it be
Mr.
5th of March?
huh?
If it is not on 17, can it be on the 5th of March?
Why?
Because on 26 we have some other matters.
Before that, then
Your Lordship, 17 or 19, we
19.
Lordship, 17, 19, this week we have problem, Lordship.
Why? 2016 matter. 19. Make it, you arrange yourself. Okay?
Should be so.
Here's a problem is for the petitioner.
5th March.
5th March, then, Lordship.
26.
Yes,
5th March.
5th March.
5th March, then, Lordship.
5th March.
Either a 19 or 26.
26, then.
26. Huh?
Okay, Lordship.
It is made clear that no further adjournment shall be granted on the next day. 26 March, huh? Accordingly, you arranged.
Lordship.
May it please your lordship, I beg to mention item number 27.
Yes.
The leading counsel, Mr. Yasper Thakur, out of station.
On the prayer of MS,
Joya Chando.
huh?
Joya Chando.
Learned counsel appearing on behalf of Mr.
S. for Thakur.
S. Thakur. Let this matter be listed after 2 weeks.
My pleasure.
May I please, your lordship? Lordship, beg to mention item number 29, your lordship.
Hmm.
In this matter, Mr. D. Gogoi is appearing. There is some difficulty, your lordship. Your lordship.
On the prayer of Mr.
Gogoi,
R.R. Gogoi, learned counsel.
for the petitioner, lordship.
Let this, learned counsel for the petition, let this matter be listed after 2 weeks.
Obliged, lordship.
May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 11.
Hmm.
Senior counsel Ken Chaudhary sir is out of station.
11.
Yes, sir. And we adjourn the matter.
Your MS
O Gupta. O Gupta.
or Gupta, learned counsel appearing on behalf of Mr. Ken Chaudhary, learned counsel for the petitioner. List this matter after 2 weeks.
Obliged.
I beg to mention item 8, lordship. Yesterday we have circulated one
On the
advertisement.
prayer of Mr.
A. Chetty, lordship, on
H. Learned counsel for the petitioner. List this matter after 3 weeks. No, 2 weeks. 2 weeks. 2 weeks.
May I please, Your Honor? I beg to mention item number 22. I'm on behalf of BK Sharma. He is not present because of his father's illness. So kindly pass over the matter for
On the
the
prayer of MS,
as Dhingia.
is the learned counsel appearing on behalf of Mr. B.K. Sharma, learned counsel for the petitioner. List this matter after 2 weeks.
it is a interim order operating, so it's not continued.
Item 8.
Item 8.
Interim order first.
May I please? I beg to mention item number 9, my lord. Lordship, may kindly pass over the matter for today only, my lord.
Why?
My lord, actually, what happened actually, my name is not reflected in the first list, and as such, my lord, I missed the item. That is the difficulty.
What is the matter?
Matter is nothing, my lord, proportionate pension, whether I am entitled for proportionate pension or not, after completion of 10 years of service. They given me dismissal order with retrospective effect, whether it is permissible or not. That is the point.
On the prayer of Mr.
Yes, Chaudhary, lordship.
S.
Chaudhary.
Chaudhary, learned counsel for the petitioner. List this matter after 2 weeks. Registry to reflect the name of Mr. H. Chaudhary, as learned counsel for the petition in the cause list.
Yes.
Yes,
Item one.
May it please your lordship,
yes.
may your lordship kindly adjourn this matter for today.
Why?
I'm appearing on behalf of MP,
Huh?
because my senior is not available. MP Sharma, on behalf of MP Sharma.
Why?
Uh,
What happened to him?
actually, we couldn't contact the petitioners.
Will dismiss?
Lordship, kindly, release this matter again after 2 weeks.
2017 matter. Yes, what is your stand? Regularization.
My lord, the thing is that after Upendas, my lord, this is the stand, my lord.
Hmm?
We have filed our affidavit, my lord.
Saying what?
My lord, that in para 11, my lord, we have stated that they were not engaged in any vacant post, sanctioned vacant post, my lord.
Hmm.
So that is, my lord, Uma Devi, my lord. Without a sanctioned vacant post, we cannot go ahead. And now this Upendas, without a sanctioned and vacant post, my lord, that becomes difficult for us even. There is a point, my lord, for the finance department that we cannot do, following my lord Upendas.
There is a order of this court.
My lord, yes.
Consider the case of the petitioner and if he is entitled to be appointed as per annexure. It is based on circular 2019-95.
That is all gone, my lord.
Hmm?
Now, my lord, after Upendas, we have new circulars. Everything overrides.
Very difficult. They may not be interested, will dismiss the writ petition
May your
for
lordship
non-prosecution.
please give us another 2 weeks so that we can
On the prayer of Mr.
H. Pame,
Ah,
H. Pame.
H. Pame, learned counsel appearing on behalf of Mr. MP Sharma, learned counsel for the petitioner. This matter after 2 weeks, it is made clear that no further adjournment shall be granted on the next date. Mr. Arthur Learned State Council is present.
Item two.
Yeah, please, your lordship. My lord, today we have some difficulty. My lord, kindly pass over the matter for a day, my lord.
2017 matter.
18 matter.
What is the matter?
Matter relates to voluntary retirement from service, my lord.
Hmm?
To her voluntary retirement from service due to her illness, my lord. My lord, kindly pass over for a day, my lord.
Yes. Please for the respondent.
The water supply. They have a standing council, my lord.
Where is? Where he is?
In the post is nice. Do not know, my lord. His name is there, R.M. Das.
She has filed an application for voluntary retirement.
ঠিক আছে। For the day, ঠিক আছে, no issue. দাদা দিতে পারে তো। ঠিক আছে, no issue. রাজেশের এখানেও 2 নম্বর। রাজেশের এখানেও 2 নম্বর। কার? আমার কেন নেই পেতে বলছিল? সবকটা আমাদের বেশ কেন বলছেন তো? এবার সেখানে 3 নম্বর। কি করছেন? তোমাদের মতো প্রিভিলেজ না আমরা। I'm not just like privileged counsel like you. Government is taking care of you. Care of us. আমার কাজের উপরে প্রতি ঠিক আছে, তোমার এক্সিস্টিং প্রবলেম আছে না? ওইটাতে প্রবলেম আছে তোমার মধ্যে। এত জুনিয়র গভর্নমেন্ট প্যানেল আমাদের লোকে আমার প্রাইভেটে প্রবলেম আছে। প্রবলেম মোশন প্রবলেম মোশন মহিলাকে তখন কি হয়েছে?
Remain absent for unauthorizedly, you remain absent from the duty.
Kindly pass out for a day, my lord.
Why it should be adjourned?
Today, my lord, we have some difficulty, my lord.
Why?
Because we have not ready for hearing.
Yes.
We have filed our affidavit, lordship, in the
Yes.
affidavit, we have
So you
specified
said
things
that
that
you'll consider her application. Huh?
consider, but the thing is that this certain aspect of the matter cannot be overlooked, lordship. Because the unauthorized absence part is also there.
Whatever you want to do it.
Lordship, can be fixed in the next week, so can finish it.
Whether
off.
you accept or you reject it.
If the direction is
She
like
is
that,
still-
yes.
She is still, she has the tenure now. Or she's retired.
Because of her health condition, she is inclined to this on voluntary retirement.
You decide why you keep it pending. Whether she is entitled to be considered for voluntary retirement.
Next week, lordship, next Tuesday, I will obtain the necessary instruction if they are in a position to pass the order, speaking order with regard to the representation.
She is still working.
No, she is not working, lordship. Unauthorized absence for a long period of time.
$1,506 salary. You have not taken any action.
Because of her
Why?
health no, the reason is that because of her health condition, because on the various occasions she submitted representation enclosing certain medical documents, but there is a limit to all this.
You reject it or not, I understand, maybe she is having a health problem, health issues. Then you accept or reject it. What is this?
Obtain the necessary instruction with regard to that.
Her MS so and so learned counsel for the petitioner.
Elbow.
Huh?
Elbow.
Huh?
Elbow, my lord.
And Mr. S.B. Chaudhary learned counsel for, standing counsel for,
Water Supply Sewerage Board.
it's a board.
Yeah.
Correspondent number,
Phone number.
Assam Urban,
Water Supply Sewerage Board.
Water Supply Sewerage Board. Correspondent number 3 and 4. Mr. Next matter pertains to voluntary retirement on the ground of health problems, which appears to be it appears that Isn't, till today, no decision has been taken by the board, either accepting or rejecting the application for voluntary retirement list of in view of above. Let in view of above, let this matter be listed after a week. On the next date, Mr. S.P. Chaudhary, learned standing counsel to obtain instruction. Yeah, just after a week.
My lord. This is a, this application is for the grievance of the petitioner that and also prayer along with to consider their claim in future vacancy. Only this up to that, my lord. Admittedly, having no merit in the, because the jury project which I have speak of here, my lord, about this jury, that is already over. Thereafter, my lord, this petition about 171 petitioner here, my lord, their future is in question. They submitted representation, getting a notification in the paper that some 12,000 posts will be taken in muster roll. So for their only, my lord, that's why this notice has been issued at that time, one my lord, in 2018, my lord. Because only for this, my lord, this they are the least expectation and the hope of the.
So who is, have the state filed a affidavit?
Nothing filed by them, my lord.
Huh?
Nothing filed by them. My prayer is, my lord, 10, kindly see, my lord. There is a particular, I have attached annexure to page 102, my lord.
What is your prayer here?
Here, my lord, only to consider page 35.
Engaging them to the post of master roll worker and work charge helper in various departments government on a humanitarian ground, if any master roll vacancy arise in future, to dispose of reports submitted with as per.
It's a limited prayer, my lord.
Not possible. It will be a futile reach.
But an advertisement, kindly see, my lord, page 102, my
But
lord.
doesn't matter. You apply, you go there. Have you participated?
No, my lord, that post has not been, thereafter, no process has been taken by the
No.
government also.
It's up to them. We cannot compel them. We feel for you, but can't help it.
My lord, any kind of observation, my lord, the future of
Yes.
this,
Well, dismissing it.
my lord, I'll take instruction from the client what to do, either to withdraw, my lord, because
Huh?
let me take the instruction from the client, my lord.
No, we are dismissing it. What withdraw?
In that case, my lord, a representation may kindly be considered, my lord.
No, that will be futile.
As
When
per-
when you don't have any right,
Yes, my
how
lord,
can you be-
admittedly, there is no right.
and that too in 2018.
Only thing, my lord, as per law, my lord, they may,
What as per law?
the representation may be
No.
considered, my lord.
Admittedly, you were appointed on
Jury project, one project I have.
one
we are
project
appointed.
which is no longer there.
Yes, my lord.
Then
Thereafter, my lord, advertisement will be made in a paper.
so what?
My lord.
You participate. Who has stopped you? And if they have not taken steps, it's up to them. We cannot compel them to fill up.
My lord, regarding this, they have also not filed any.
No,
affidavit regarding-
it's not necessary. Affidavit is not necessary. First, you have this your writ petition. You have to establish your case. Yes, take down. Who is for the respondent?
My lord, then I may be withdrawn, my lord.
Huh?
I may be withdrawn. This is the case, my lord.
But no liberty, no case.
My lord, that will be seen in future.
Certain cases where you cannot just afford,
Yes,
but
ma'am.
wherever it's possible, whatever, at least, I mean, small way out, we would like to grant the relief, but
My lord, when
this will be unnecessary.
My
Yes,
lord-
heard, mister?
my lord, may I submit before that? My lord, the time of when the case has been filed, my landed my late senior A.M. Mohinder sir was there, my lord, in this case. The court considered only on the fact that the humanitarian relief on that
That
matter.
cannot be done.
Equity on equity, my
No,
lord,
no,
that's
no, no.
considered.
Either you are withdrawing or you are dismissing.
My lord, I may be allowed to do.
Heard, mister?
A.Y. Chaudhary.
A.Y. Chaudhary, learned counsel for the petitioners. Not heard, Mr. A.Y. Chaudhary, learned counsel for the petitioner, fairly submits that he may be allowed to withdraw this writ petition as no relief can be granted to the petitioner in view of the fact that the petitioner was appointed, engaged, right?
Yes, ma'am.
Engaged, temporarily engaged in a project, namely Giri irrigation project in the Barak Valley region, the project which has already been completed, huh? Mr. The prayer for withdrawal is accepted. Accordingly, writ petition stands closed on withdrawal.
Right.
May it please your lordship.
Yes.
Lordship, matter is pertaining to compassionate appointment, lordship. Lordship, it's an old matter. It's an old matter, lordship.
Over. Yesterday, we have allowed 2-3 matters to withdraw with the liberty to file afresh if so advised.
Lordship, this is of
Because until that,
2000?
yes, until that time, it's your ill luck due to the subsequent developments because of the new notification,
Lordship.
circular, which has not been, it was challenged before this court. It was not interfered with, but then certain direction was issued.
Which notification, lordship?
2004,
Lordship,
24, 24.
then Lordship.
Where
89,
all this
24.
scheme
Lordship,
policy has been done away. And there is
Lordship.
no, provision for compassionate, when it's a compassionate family pension. And that was put to challenge, like you, that earlier, those who have been.
Not pension, lordship.
Huh?
Not pension. This matter doesn't relate to pension. Compassionate appointment.
Sir, I am telling you,
Lordship.
there is
Okay,
a
I've not seen
notification,
the-
sir, the latest notification
Lordship, I have not
or
seen
the circular of the
Lordship.
government whereby all the scheme for compassionate appointment has
Lordship.
been done away.
Lordship.
And instead of compassionate appointment, there is a provision for compassionate family pension.
Lordship.
So that has been put to challenge before this court in
Lordship.
many cases.
Lordship.
But then that was disposed of, providing some direction. So you find out and file.
Lordship, in this matter, Lordship, they had considered my case and
The same
rejected
thing,
it in the
and
wrong,
again
with
rejected.
wrong ground.
Rejected, considered
With
and
wrong
rejected.
ground, with wrong ground, Lordship.
Considered and
In
rejected.
violation of the, our court's order, Lordship.
Cannot be.
Ashut Ranjan Das was there, Lordship, that was violated.
If there is a violation, you file a contempt. Sir, you find out and
Lordship.
we'll give you a liberty to you unless you challenge that.
Lordship.
Cannot give
Lordship,
anything.
can I have a copy of that notification?
You find out.
Cases 18/9/2024 and
There are
then
series of
subsequently the
matters.
executive order of 2025, 30th August 2025.
There are a series of matters.
Lordship. I may be given 2 days, Lordship, I will go through it, Lordship. I will take the liberty, Lordship, from your Lordship. Lordship is here.
No, it's not question me or who.
Sorry, Lordship, but
Anyone can take up what's there. What I'm saying that similar matter we have allowed to withdraw with a liberty to file fresh.
Lordship,
Because this court also passed some orders.
Lordship,
They'll give you a liberty,
Lordship.
you withdraw it in view of the subsequent developments. All right. Heard, Mr. Bhagwati?
Lordship.
M. Bhagwati, learned counsel for the petitioner. No, Mr. Bhagwati, learned counsel for the petitioner submits that he may be allowed to withdraw this writ petition with a liberty to file afresh.
Lordship.
Prayer for withdrawal is accepted. Accordingly, writ petition stands closed on withdrawal with a liberty as prayed
Lordship,
for.
withdrawal reason should be given, Lordship, because of the notification, Lordship.
Huh?
Otherwise, I would not have withdrawn. Because of that notification, I am withdrawing, Lordship.
Yes.
Otherwise, if your Lordship order says that, simply I am withdrawing, Lordship.
Yeah, in view of the order, so you
Lordship.
give that.
Lordship, in view of the order, Lordship.
What I say? With the writ petition, in view of the subsequent circular, namely so and so, office memorandum or something like, you just provide.
In 2024 Lordship,
Oh,
and
that
then
is-
the honorable course coordinate bench
Just a
order.
second. Office memorandum 18, 2024, whereby, by which the policy oblique scheme for compulsory appointment has been done away by replacing the provision for compassionate family pension.
Family pension was introduced in 2017
That is,
Lordship.
that was on.
It was earlier.
2020.
This is all the compassionate appointment has been abolished Lordship.
No, no. Where this, you have seen that circular. Am I wrong? It clearly provides instead of compassionate appointment, the family pension, compassionate family pension will be provided. It says so. Then you just say in that case, if you are there, if you are not, if they are not satisfied, then you said that in view of the office memorandum, so and so, whereby all the
Lordship.
so and so has been done away. With a liberty to file fresh. Then you say that you record their name. Prayer for withdrawal is accepted. Then accordingly, so and so is closed as withdrawn with a liberty as prayed for. You challenge that you may.
Lordship.
I think by this time, I think you might have missed the bus.
Lordship. Understood.
We'll see, but then that was something, some conditional orders were there.
Lots of Lordship.
Lordship may take up this matter at 2 or fix this matter for next week.
Why?
As for Ali is on legs in another court.
Who?
As for Ali, the lead counsel.
What is the matter?
This is regarding termination of the petitioner's service, who was working on contractual basis. my lord. We have challenged it that she was discriminated on the ground of her being pregnant. So she was.
Your colleagues' service have been extended.
Extended.
Then?
Yes, my lord. Actually, she was a contractual employee actually.
Doesn't matter.
Yes.
Then why you have not, why you have extended other similarly situated persons?
Because she was appointed in a specific post which was actually required for specific purposes, not other colleagues actually.
Yes, clearly similarly placed contractual employees were given the benefit of extension of service and maternity benefits that the petitioner is being sought to be removed.
Maternity benefit we have already provided to her.
You have extended only for 2 months.
2 months. And
2 months means earlier we have extended, my lord. Since the project, because that is the institute is a research institute, your lordship.
Project
Sometimes
is over.
yes, my lord. That project, that specific work is over, so there is no requirement for her work. That is why it cannot be extended. And we have not appointed anybody in her place.
Now, once project is over, Kalpana Das.
This case reply affidavit was to be filed, actually they have not filed till now.
Huh?
Reply affidavit against our counter affidavit.
2 weeks time may be granted, my lord. We'll file our reply.
What reply?
Today, affidavit in opposition.
Huh?
2 weeks time may be granted. We'll file our.
For
affidavit.
what? See, you were appointed on a particular scheme and that scheme is over now.
My lord, in their affidavit, they said that I did not apply for maternity leave.
Forget about this. Now there's nothing. The 2 months further extension up to,
Was given, and during that period, I
Was
applied
it
for
up to-
maternity leave,
up to?
May 18. 2018, May 2018. 15 May 2018. I think.
It's
And
there.
during that period, I did apply for maternity leave. But they didn't extend.
No, no, it's okay. They have not been given to you. It's okay. We understand. But then nothing remains. When the project is over, where's the appointment order? First initial appointment,
14.
page 40.
No, in the year 2014.
Just show me the appointment order.
And it's a B, page 23, the repetition.
Page 23. Recruitment to the post of office assistant. I'm glad to inform you that you are selected for appointment to the post of office at the Institute of Administration. So, as per the current selection in its meeting held on Sunday and with the approval director Anu Thompson. Contract service will be for a period of 3 months from the date of assuming the office. Then it was extended
Extended. They
from
kept on
time to
extend-
time. Last extension,
Fourteen three 18. The order was on 14/3/18 with effect from 13/3/2018.
page 55.
55.
The other, for a period of 2 months. Yes, then
Then
you filed the writ petition.
My
When
lord?
did you file the writ petition?
May, May
This was
2018.
March, right?
Yes.
You
5th
filed the writ
2018.
petition? When did you file the writ petition?
5th May 2018.
Huh?
5th May 2018.
5th May, after 2 months. Hmm? Oh, before expiry.
Before expiry, my lord. In their affidavit, they said that I didn't apply it during my, I applied it after expiry.
Was there any interim order? Was there any interim order?
There was. Till the returnable date.
Then it was extended from time to, are you still working?
Not working.
May I please, Your Lordship?
Yes.
I was in court number 2. My lord, initially there was an interim order allowing her to continue, but in spite of that, she was not allowed. Then, due to her pregnancy and all, so she had some complication, my lord, and we wish to file an, my lord, additional affidavit because thereafter some additional facts are there.
See, you were appointed on particular scheme. According to them, it's already over.
Yeah.
So where do you, I mean,
But
we-
there
we
is
will be
clear
adjusted.
violation of provisions of maternity benefit act.
it's okay. That was during that.
Because at the time of pregnancy, they have discharged her. They have discharged her and that is clear violation of the provisions of maternity benefit act.
During their service.
Yes,
After the extension of 2 months.
yes, my lord.
After extension of 2 months.
No, not extension, my lord.
When it was-
Yes, that extension was there and thereafter she was terminated, my lord.
Huh. Then
So that was during her pregnancy. That was during her pregnancy. At that time, she was about 6
the
months.
problem is you were appointed initially for 3 months. You have
No,
accepted.
we have not referred for it. It is them. Because time to time, our service was
just-
extended.
Just listen. You were appointed for 3 months initially.
initially.
They have extended your service from
Yes,
time to
and
time.
after due selection process,
Doesn't
after
matter.
due selection process.
It is for particular scheme.
Yes, madam.
It's for particular scheme.
Oh, not under particular scheme.
And they say,
There was some requirement and on that basis only.
yes, it was for
That-
3 months and then extended.
Yes, extended even
you
up
have
to
served-
one year also.
Served
sometime.
it, served it. Up to 2018, you were, I mean, May 2018, your
Yes.
service was there.
Service was there.
So,
And my lord, Lordship will see time to time there was her performance appraisal. And considering her performance appraisal, it was extended.
so
And because of her
performance
pregnancy,
appraisal was for the extension.
yes, performance appraisal was for extension.
So
And
then,
if your lordship consider all this report only during the time of her pregnancy, her performance was not up to the mark.
what is your statement that in view of the completion of the scheme, her service is not required? Have you made any statement?
Because we have stated in our affidavit.
So what?
Because, yes, my lord, the extension and the contractual appointment has been made only because of the requirements of the particular project.
What is particular? Show us whether it has been completed or not. Show us.
It is not reflected.
You show us whether it is.
If it we have stated,
Show us from the affidavit, sir.
So by affidavit, they cannot improve the matter. In the order, it is not reflected. That scheme came to an end.
It is not required. Your
And that is why
what is the termination order?
In page 55. At page 55, Annexure K.
55 is not termination.
yes, my lord.
No further extension will be made after the expiry of 2
Expiry of
months.
2 months period. Yes.
So,
So by challenging this order, we came before this honorable court.
we cannot,
And there was an interim order. And that interim order was also communicated to them. And in spite of that, well, in clear violation of, she was not allowed to continue.
so then what you did? Did you not avail the remedy when the order of the court is violated?
That is why we want to file an additional affidavit.
Okay, no.
Yes, my lord. We want to file an additional affidavit, my lord. That is why, my lord,
For
why,
what?
stating our difficulty, why at that time we could not file, go for contempt and all. At least 1 week time may be granted.
What's there nothing? Show us.
Yes, ma'am. In our affidavit, your lordship,
There is no termination. Your contract of employment, the service was extended for another 2 months on your application, after considering your application,
Yes.
right? Then it says that no further extension. There's no termination as such. You're bound to go. Now show us
yes,
that.
my lord, in the, my lord, page number 7, my lord.
Ah.
Para 7, my lord, in our counter affidavit, in page number 2, my lord.
Running,
We have said-
running page,
Running page,
affidavit on behalf 2, 3, 4, and 5. Affidavit filed on behalf of
register, respondent number 2 and 4, my lord.
2, 3, 4, and 5.
So 2, 3, and 5,
Not 4.
not 4, the chairman. Chairman of academic, the institute. 5 registered. And 3 is director. And
So
2,
where
3,
file
and
this?
2, 3, and 5.
Huh?
3, 4, and 5, off.
Then that is what I'm saying.
Yes, my lord, in the para number 7, my lord, in our affidavit, we have stated. Since it was filed long back, so continuous page and the running page, it is not.
Where did you say? Nothing?
Specific work for a specific period, my lord. That
You
we
said
have
some
mentioned.
scheme.
Yes, here scheme is not reflected, my lord, only the specific work. So we have to appoint some contractual employees to mitigate the workload. That's what we have stated. And also in the
Then why did you say earlier? Why you said that she was appointed on a particular scheme and the scheme is over? Why did you say so?
So in
You
the,
made a false statement.
no, my lord,
Sir, you made a false
no, my
statement.
lord, sorry.
We're
for
taking
that,
two
my-
photo against you.
No, my lord,
Why?
sorry for that, my lord.
Unnecessary. This is a false statement by a council. Then, see, if you are not prepared, we'll grant you a time. But don't make a false statement.
Sincerely apologizing, my lord.
It's a false statement on your part. Why did you say so?
I'm sorry, my lord. I'm sincerely apologizing, my lord, for that, my lord.
We thought we'll dismiss the writ petition. Because you your false statement, we will allow the writ petition. Have you not said so? That she was appointed on a particular scheme, that scheme is over.
Yes, my lord.
Have you not said so?
Yes, my lord.
Just a while ago.
I'm sorry, sir. That is not correct.
You are saved because of him.
No, it is.
On the prayer of Mr.
Yes, Morali.
S. Borali, Land Council for the petition. Further 1 week time is granted to file appropriate affidavit. No, I'm not as to file affidavit, additional affidavit.
It may be affidavit in reply.
Additional affidavit and additional affidavit as well as affidavit in reply. Mr.
D. Google.
D. Gogoi,
Yes.
should I record your statement? D.
I'm sorry.
Gogoi, Land Council for Science, respondents is present.
For one, Union of India.
Yes, are present. Record. Mr. Borel, you are saved by him today, at least for today. Please be careful, sir, huh? If you are not, I mean, it happens. You may not have a time to go through. If you are not sure, don't make such a statement. It's very, I mean, it's a misleading in fact.
Sorry, my lord.
Please be careful.
Obliged.
Problem.
May I please your lordship? Lordship, we want to withdraw our wakalatnama from this case, your honor.
Why?
Lordship, no instruction furnished by our client, and we have already sent a register letter.
What is the matter? Yes, when you have no instruction
No, lordship.
from the client, then
Anyways, their contractual period has already been over on 2017 itself.
huh?
Period is already over in 2017 itself. Thereafter, there is no extension order or renewal. Page 21.
But there's an interim order, 16/5/2018. In the meantime, the post of MIS manager in Silchar, Bakandi, Borkhala and Arkansas should not be filled up through new recruits in pursuant to the advertisement so and so without leave of the court. What happened?
they made a submission on 20, there is a court order of 28/6/2023 that the advertisement has been went ahead with and appointments have been done, new.
Matter be posted vacation enable her to obtain stern being raised by the petitioner in Spain. Earlier, the requirements were reprinted in the middle. Presently, the department has a separate set of restraining orders. Then also the petition, although an interim order was done. Appointed the new recruits in terms of the petitioner are presently not allowed. Yes, on 28, you wanted to file some,
Lordship, we are supposed to file implement petition, Lordship.
hmm?
We are supposed to file implement petition, but no instruction has been punished to us, Lordship.
Let us see your letter. How do we know that this has been received by the petitioner? Has it been duly received? You have not filed affidavit. Huh? No, no. Have you filed the affidavit? Why? Heard MS speech
ADAS.
ADAS, learned counsel for the petitioner, who submits that. He has sent a letter. No. A letter was sent on behalf of MS P. Chakraborty, learned counsel for the petitioner, informing the petitioner on 4/6/2024. One of the, how many petitioners? One of the petitioners on so and so that 4/6/2024. Madam,
Lordship.
whom you have sent, this is MS Hasina Begum Talukdar.
Lordship.
There's no name.
Lordship, there's a second, there's a second petition.
Okay, second read please.
Yes, that's item 7, I believe.
Okay. Item 7.
Lordship.
You have sent both the
Yes.
in the both the cases. Then in that case, Hasina Begum okay. What is it? Oh, you right, letters have been sent to the, letters were sent to the petitioners informing that in view of not furnishing information instruction, enabling the land council to take appropriate steps, they wish to withdraw their power from the their power in the case. Mr. Hauber, no information informations were forthcoming. Next, the petitioners were engaged as block MIS manager within bracket PMAY dash G, bracket close. As per the contract agreement dated 6/06/12/2016 under the establishment of different blocks in Kachar district. Next paragraph. Apprehending replacement by a new set of contractual employees pursuant to the advertisement dated 14/06/2017 in person, issued by the Commissioner, Panchayat and Rural Development, whereby 9 posts of district MIS manager is not was notified for contractual appointment. About these writ petitions were filed, and these writ petitions have been filed. On 28/06/2023, Land Council for the petitioners has submitted that although an interim order was earlier granted by this court, but the respondents have appointed the new recruits in terms of the advertisement, and the petitioner are no longer, petitioners are present, are not allowed to work, continue to work, Next paragraph. Having considered that despite letters by the engaged counsel, despite letters seeking instruction, public information and instruction for taking steps in the matter, no information appears to have been supplied to the Land Council for the petitioners, which indicates that the petitioners are no longer interested to pursue the matter. Pursue the matter as they have been disengaged from their services, and the post appears to have been filled up pursuant to the advertisement dated so and so, huh? List of NBO, read petitions, these read petitions since dismissed for non-contribution.
May I be your lordship? Lordship, the petitioner lordship, he is working as a junior assistant and is seeking promotion as senior assistant. My grievance is that lordship for the last 10 years and so, not a single candidate from ST plain candidate has been promoted. And even if a candidate is not able in a particular year, they should reserve it. And they can unreserve it only after 3 years, lordship. That is not done, lordship. And lordship,
Yes.
there is one more vacancy has occurred now also recently in 2022. Lordship, I can also be accommodated in that lordship post lordship
Lordship,
without disturbing the private respondents.
we have filed affidavit. And we have denied whatever they have actually stated in our affidavit. And to which they have not filed a reply till date.
No. Lordship, there is a
If
development,
they-
lordship. The affidavit was filed by the divisional commissioner. That office is no longer there. We cannot file a reply to an unexisting office, lordship. Now it has been merged with the district commissioner, lordship. That is why, lordship, I have filed an interlocutory application, implemented all the necessary parties. Now JAD is the administrative control and this lordship office has been merged with the district commissioner, Zorat. I can't file a reply where there is not an office, lordship.
And respond number 8, DC has been impleted as a party. So this affidavit as such can be treated on behalf of the DC itself. Now, if they want to file a reply, they are most welcome to file a reply.
No, on the last occasion, lordship,
Yes,
they were
he himself has
directed.
stated
When
JD.
the affidavit was filed,
Affidavit was filed by the divisional commissioner,
it's
lordship.
okay, that time. Now that has been merged into district commissioner.
Lordship.
District commissioner.
District commissioner.
It's just a nomenclature has been changed.
And
Right?
lordship, and the ZAD is required to file an affidavit. That is the last order. lordship.
Huh?
ZAD department. In the last
JD
order, it
for
has-
what? A spread for Mr.
Lordship,
F.
otherwise,
Gone
I could have filed my reply long back, lordship.
on the date.
Because
to
of the
fix-
situation.
No, what he's saying is Fukan. Yes, for respond number 7, GAD.
No longer the main party, my lord.
Huh?
Earlier, the upwards of division was, my lord, since it was abolished, my lord. For some time, stopgap period, my lord, the GAD was made the main authority. Now,
Why?
I think the DC will be the main authority now.
This is promotion from,
Junior assistant to senior assistant.
then,
Authority is, my lord, the DC, my lord.
no, he's saying some fixation of quota,
Yes.
reservation, I mean,
Okay.
reserve.
And lordship,
Therefore, I think GAD will be the authority to, I mean,
My lord, I'll get my instructions, my lord.
what instruction last time you have in 2024?
Because this petition can be disposed of altogether.
Huh.
So the affidavit itself says that they will be considered as and when the vacancy arises.
Huh.
And we have promoted the private respondents as per the roster point in the unreserved category.
lordship,
You
I
are
can-
challenging the
lordship,
roster.
I
If
can
they want
prove,
to
lordship,
take it, then they have to file a reply.
I can, lordship, I can prove from my writ petition itself, lordship. They have not maintained the roster. One Rekha, lordship, Chakraborty, she was promoted under the unreserved category.
No, before that,
Senior-
you said that there is there's a vacancy now.
Yes, now there is a vacancy.
Whether that vacancy is reserve thing.
So that contention,
2020.
that is Rekha Bora, who was promoted, she belongs to unreserved category, that is the contention of the petition. But the affidavit here stated that she belongs to ST plains.
They will have to bring the on record also.
No, he said if they say that if it's
Only on
you are
record.
saying that he's from general.
Then
General and on the basis of seniority, she has been promoted long back in 2000.
It's okay, but then she has been promoted in a reserve quota because he or she is a ST plain.
Not under the.
You are?
I am ST plain also.
Huh?
I am ST plain. For the last 10 years, lordship, I have given lordship. Last 10 years, lordship, they have promoted senior assistant from OBC, general, ST hills, SC, general, OBC, and no candidates from ST plains.
He said,
affidavit,
He is saying of it without any record, lordship.
then I'll produce the records and everything.
Without any record, lordship. Only a statement has been made.
you have not
From-
replied
no,
that.
No, from my.
You have not denied that. I mean, kind of, you
No,
have
I
not.
could have, Lordship, I could have made a reply because this office is no longer existing. That is why,
Doesn't
Lordship.
matter. When the office was there,
Lordship.
they filed it and it's been redesignated or whatever. Designated or redesignated, whatever.
No, that office has been abolished, Lordship. The
It
affidavit
has
filed
been
by,
merged. It will come under the district commission only.
District.
that was filed by a special officer
Sir,
to the commission.
are you want to, that matters should be adjudicated?
Lordship.
While going into all these things, when the affidavit was filed,
Lordship.
that time the office was there.
Lordship.
Somebody has signed the affidavit, the officer has signed the affidavit, the defendant has signed the affidavit.
Lordship. Before
Now that office has been abolished
Okay.
and it's been now under the district commissioner, same thing. See, matter is very simple. What you are saying for so many years, violating the roster
Lordship.
or the reserve post, no reserve candidate, particularly ST planes, has been promoted. What they are saying that one person, this is the person who is the ST plane who has been promoted. Matter ends there. Is not it? Now, earlier, while ago, you said that there is a vacancy. If there is a vacancy
Lordship.
which is reserved for ST, your case can be considered.
Lordship.
I mean, ST plane. If it is for ST plane, are you saying so?
Because my contention is that no one has been promoted from ST.
Your contention has been debated by them that they one person. What is the name of that?
Rekha Bora, Lordship.
Rekha Bora.
Annexure 9, page 33.
Para 13 of the writ petition. That is the contention.
Annexure 9, page 33.
And now reply to para 30.
There are 13 of writ petition. Vijay Mangai.
Vijay Mongol Neok, senior, was again promoted to post of superintendent precisely on 4/4/22. Resultantly, now one post is lying vacant for senior assistant. The respondent authority ought to have filled up the promotional vacancies from the category of ST plane, which was filled up on 2012-2021 following the DPC manuals held on 1/12/2021. The same being not done, now the present vacant post of senior assistant is required to be filled up from the category of ST plane by promoting the petitioner. Now, our reply to para 13 would be
Where it is? Page?
Filed by respond number 2, respond number 3.
Yes.
Para 9.
Hmm.
Para 13 of the writ petition, the deponent states that a post will be filled up as per 13-point roster. 13-point roster.
Then?
So it will be filled up, your lordship, as per the 13-point roster which is maintained in the office. His dilemma as such has been addressed as and when that particular post will be filled up, as and when that process is initiated by the department.
Where you have said Rekha has been
Para 5.
during the last 10 years, 1 month, Srimati Rekha Bora, LDA, belongs to ST plane category, was promoted as it on. That is 06/09/2012.
2012. She has been superintendent in 2020. And Lordship, my contention, Lordship may kindly come to Annexure 9, page 33. She was given promotion on the basis of seniority or in the unreserved category. Although Lordship, her caste has been shown as STP, but she was given promotion
Where
on the
it
basis
is?
of
Page 33.
page 33. Lordship may kindly see serial number 1.
Rekha Bora.
Lordship.
Serial number 1.
Draft gradation list of.
Yes,
Office of
Lordship may kindly see her date of appointment 1986, date of confirmation 1998, and she superintended in the year 2020.
Her category is STP, your lordship. How come my learned senior is saying unreserved category? I don't understand that. Rekha Bora STP within brackets.
Not as a ST plane category. She was given promotion on the basis of seniority.
From where
and
you are
unreserved
saying?
category.
Where you are saying?
Lordship,
From where you are saying?
From this list only, Lordship.
This is the gradation list of the office of the gradation list.
Gradation list.
What is her promotion?
Our promotion order also is not available with me, Lordship.
Then
I
how,
have to provide
how,
the records.
sir, then how you are saying so from this gradation list?
Because
This is a gradation list of what, the
2018-19.
and date of promotion is shown as 6/9/2012.
hmm?
6/9/2012.
So,
Date of promotion.
so,
Now, Lordship, if we can file a reply to this affidavit, Lordship, I can file my reply, Lordship. No, that is why, Lordship, I have got included all these respondents because in the coordinated bench, Lordship, it has been told me because that office is no.
that's all,
at this time.
implement, everything is over now. What is, I am on the merit now. What is your claim? You said that nobody has
Yes.
been
Yes, that is
promoted
that-
from the ST plane,
That is my claim, Lordship.
violating the roster or
Lordship.
the reserve post. That is what you are saying.
That is my,
Now what they have said is one Rekha Bora was promoted
Lordship. That is not correct, Lordship.
from ST.
I may file, I may be allowed to file my reply, Lordship.
Anyway, it's up to you. I wanted to dispose of, in
And
any case, you are seeking promotion.
promotion,
Unless you show clear violation of the roster,
Lordship.
how do we direct?
Lordship, I will clear this violation, Lordship. I will bring all the records, Lordship, whatever is available with me. I will try
And mind you, it's not a right promotion itself. Consideration may be a right.
Lordship, that is a violation because for last 10 years, Lordship.
How it has been violated when they,
Lordship, Rekha Borua, Lordship, she was, although she may be a STP trained candidate, she was given promotion on the basis of her seniority.
from where you are saying?
Yeah.
From where you are saying? From where?
Because her seniority, because she.
Where,
got
where,
the
from
promotion.
where? Show us any paper.
Lordship, I will find my reply.
And Mr. Mr.
SK Das.
SK Das, learned counsel for the petitioner. Respondent is granted 3 weeks time to file affidavit in reply. Mr. So-and-so, so-and-so.
498, D Bora.
I appear for 7 months. A number 2. A Fukan for 1.
But Ukhan, in their affidavit, what they have said is, whatever the roster issue, that will be consultation with GAD, it will be clarified. You have to come up with clear, Mr. Fukan so-and-so
I'll get my.
is also directed to file affidavit.
Upper number 5 and 6.
What is your stand? What is your stand? Okay, then, next, we'll
Lordship,
hear
there's
you
a
on next.
technical difficulty also, Lordship. Now I have to file my reply against the affidavit filed by the special officer, Commissioner Upper Assam Division.
What does it make a difference? You just file your reply, supply it to the, furnish the copy to the thing.
They will, the district commission.
Obviously,
Keep reply.
Alright.
they are represented by the state council. You furnish the copy, that's all.
Now, Lordship.
You don't have to go and give it to the person who has filed the affidavit.
The employees have been merged now.
Doesn't matter when they say that.
Lordship.
Wait,
Yes.
the petitioner was appointed as an auxiliary nurse and midwife, my lord.
Hmm.
My lord will find that appointment letter at page 20, my lord. So lordship kindly peruses page number 20, 29/4/1992. Subject to satisfactory police verification report on character and antecedents and on recommendation of the selection committee, Ms. Dalimi Kolita, that is the petitioner, is appointed temporarily as auxiliary nurse and midwife in AACB dispensary Sondrapur in the scale of pay of so and so, my lord. So this is my appointment letter, my lord. And 2000, my lord, 18, I was transferred to Bijuli Bhavan. Page 25, my lord. Page 25, my lord. So this is, I was transferred to the Bijuli Bhavan. 2018. And during the course of employment, my lord, if your lordship kindly turns to the next page, page 26.
Your lordship will see, my lord, page 26. Similarly, identical auxiliary nurse and midwife, auxiliary nurse, page 26. There's an order dated 21/6/1990. In the interest of board's work, AECB, Srimati Rukhomati Mosahari is hereby provisionally appointed as auxiliary nurse in the scale of pay of so-and-so. Now we came to know, my lord, page 26 and page 20, my lord, if conjointly, if your lordship peruses page 20 and 26, your lordship will see my scale of pay is, my lord, lower, my lord, although we are in a identical post. Thereafter, my lord, we approach the authorities, and the rejection, my lord, will find at page 31, my lord. Page 31, my lord. There's a rejection of 1/2/2022. We submitted representations. We approached the authorities, and this is what they said. On 1/2/2022, references your applications dated 21/2/2020 and 27/7/2021. With reference to the subject cited above and the appeal raised by you in the matter of discrepancy in your initial fee pay fixation, this is to inform you that your matter was examined thoroughly. But after examining all the facts and circumstances, it is observed that the matter was raised after a considerable lapse of time. That is, after almost 30 years, as your appointment was on 29/4/1992. Hence, in view of the above, your prayer regarding consideration of refixation of your initial pay may not be entertained. So, my lord, they did not entertain my my grievances on merit. They said it is a time bar, basically. Then, my lord, I file an RTI. That RTI, my lord, will find at page 34, my lord. It's an RTI dated 33/2022. My lord will kindly see the query number 1. Page 34, my lord. Why is the undersigned given a lesser pay scale than other auxiliary nurse and midwives working in APDCL? Page 34. And the answer, my lord, will find in the next page, page 35. I asked him, why did you pay me less than the other auxiliary nurse and midwife? And they responded, right, RTI reply dated 29/4/2022, page 35, serial number 1, my lord. The pay scale of midwife is below the pay scale of auxiliary nurse as per ROP. Srimati Dalimi Kolita was, as Srimati Dalimi Kolita, that is the petitioner, was appointed as an auxiliary nurse and midwife, ANM, and as mentioned in her appointment order dated 29/4/1992, she was given the scale of midwife and not auxiliary nurse, which she duly accepted and joined in service. If there was any discrepancy in her initial pay fixation, Srimati Kolita should have raised the issue immediately after her joining. So, my lord, they say, as per their own admission in the RTI reply, they say that although the petitioner was appointed as an auxiliary nurse and midwife, while giving her the pay scale, they gave her the pay scale of a midwife and not auxiliary nurse. And therefore, my lord, it remained thus. And my lord, second query, my lord will see page 34. If your lordship kindly turns to page 34 once more, kindly see, my lord, page 34 for one moment. My second query is, why is the current pay scale of undersigned and the current pay scale of other auxiliary nurse and midwives working under APDCL? And the answer is at page 34 itself, my lord. Page 35 itself, my lord. Second answer, my lord, will kindly see, my lord. Page 35, my lord. So, current pay scale of Srimati Dalimi Kolita, my lord, basic pay is 51,480. And current pay scale of Srimati Jilika Bohoro, who is in the same post in the same department, her basic pay is rupees 68,910. So, admittedly, even the current pay scale I am getting less. And the reason is because at the time of my appointment, also, although I was appointed as an auxiliary nurse and midwife, they gave me my lord, scale in the midwife and not auxiliary nurse. And my lord will kindly see the third, my lord, third query at page 34. I again asked them, my lord, I again asked the authorities, why is the current pay scale of undersigned lower than the others? And they give the same reply at page 35. Now, my lord, finding no other alternative, my lord, I had to approach your lordship. And your lordship was pleased to issue notice. And the APDCL had filed an affidavit. Now, these documents are, my lord, indisputable. This RTI replies, these materials which I have placed before your lordship are immaterial. So they did not deny anything on merits. all they said, my lord, that this is a application, this application is time barred and it is liable to be dismissed on the ground of delay in laches. Now, my lord, my response there too would be, my lord, this is a recurring cause of action in the sense that every time, every month, they pay me lower than a similarly situated person, my lord, a fresh cause of action arises. The authorities cannot be allowed to take advantage of their own inefficiency. In this regard, my lord, Honorable Apex Court, my lord, M.R. Gupta.
Next whole Chandika. My lord, M.R. Gupta, my lord, same issue, my lord. Citation hold 1995 5 SCC 628. And the question number 2, my lord. The facts are at page number 2, my lord. The only question for decision is whether the impugned judgment of the tribunal dismissing as time barred the application made by the appellant for proper fixation of his pay is contrary to the law. And the facts are the appellant joined in the service of the state of Punjab as demonstrator in the government polytechnic in 1967. Thereafter, he joined service in the railways in 1978 and he claimed for fixation, my lord. And your lordship will see the operative portion at paragraph number 5. Kindly see paragraph number 5, my lord. Similar identical facts, scale of pay, my lord. Paragraph 5, my lord. Having heard both sides, we are satisfied that the tribunal has missed the real point and overlooked the crux of the matter. The appellant's grievance that his pay fixation was not in accordance with the rules was the assertion of a continuing wrong against him, which gave rise to a recurring cause of action each time he was paid a salary which was not computed in accordance with the rules. So long as the appellant is in service, a fresh cause of action arises every month when he is paid his monthly salary on the basis of a wrong computation made contrary to the rules. It is no doubt that it is the appellant's claim is found correct on merits. He would be entitled to be paid according to the properly fixed pay scale in the future, and the question of limitation would arise for recovery of arrears for the past period. In other words, the appellant's claim, if any, for recovery of arrears calculated on the basis of difference in the pay, which has become time barred, would not be recoverable, but he would be entitled to proper fixation of pay in accordance with the rules and to the cessation of a continuing wrong if on merits his claim is justified. Similarly, any other consequential relief claimed by him, such as promotion, etc., would be the subject to the defense of laches, etc., to disentitle him of those reliefs. The pay fixation can be made only on the basis of situation existing on 1/8/1978 without taking into account any other consequential relief which may be barred by his laches and the bar of limitation. It is to the limited extent that of the proper pay fixation of the application cannot be treated as time barred, since it is based on a recurring cause of action. So, my lord, in that case, my lord, the Honorable Apex Court said that the ground of delay and laches would not be, my lord, applicable because it's a recurring cause of action. Every month they pay him a lesser amount, it gives rise to a fresh cause of action. Sorry, 3516 of 2022.
When did you approach the authority?
My lord, I had approached during the course of my service. Once I came to know, my lord, I approached them, and my first formal representation was 21/2/2020, page 29.
Then in this case, when he approached,
In this case, my lord, paragraph 3, my lord. Paragraph 3, the line starting from, my lord, may I just read paragraph 3, my lord? The appellant joined the service of the state of Punjab as demonstrator in the government polytechnic in 1967. Thereafter, he joined service in the railways in 1978. The appellant claimed that the fixation of his pay on his joining railways was incorrect, and he would be entitled to fixation of his pay after adding one increment to the pay, which would have to draw on 1/8/1978 in accordance with the rule number so and so equivalent to Fundamental Rule 22C. The representation of the appellant to this effect was rejected before coming into force of the Administrative Tribunals Act 1985. The appellant then filed an application on 4/9/1989 before the tribunal, praying inter alia for proper fixation of his initial pay with effect from 1/8/1978 and certain consequential benefits. The application was contested by the respondent on the ground that it was time barred since the cause of action has arisen at the time of initial fixation of his pay in 1978. Same facts, my lord. Or latest on the rejection of his representation before coming into force of the Administrative Tribunal Act 1985.
this was 11 years, yours is 30 years.
30 years. Still, my lord, they say because it's a recurring cause of action, my lord. And I'll show from the other judgments that it's a recurring, my lord. Now, if your lordship can.
Oh, yes, just tell us why they are saying that, what is that, page 34 or what?
Page, that, my lord, RTI reply, my lord.
Yes.
RTI reply, my lord, will find
Why
at
they
page
say
34.
the pay scale of midwife is below the pay scale of auxiliary nurse?
So,
It's a different post or what?
no, as per them, it's a different post. But as per the ROP at page number 41, kindly see, it means one and the same thing. Page 41. This is the latest, my lord, 7th pay commission. Page 41 at the bottom, second category from the bottom, midwife / ANM. It means one and the same thing. And my lord will see the appointment letter at page 20, my lord. Kindly see my appointment letter at page 20, my lord. The third line, it says appointed as auxiliary nurse and midwife, my lord. Page 20.
Why you are?
I'm an auxiliary ANM, my lord. And in any case, and my lord, that second.
Page 26 is?
Page 26, my lord. Page 26 is that similarly situated person.
This is auxiliary nurse only.
Auxiliary nurse.
I'm
auxiliary nurse and midwife.
Huh?
I am auxiliary nurse and midwife.
So
and still I'm getting less.
What is the difference?
The difference, my lord, they will know better. But kindly see my RTI.
But you explain.
May I just explain?
When you say that this is similarly situated, when
my lord will kindly see page 35.
Page 26 has been, she has been appointed as auxiliary nurse, and yours appointment auxiliary nurse and midwife.
Kindly.
What is the difference?
Kindly see page number 35, my lord. Kindly see page 35. So, page 35, they say, the query number 1, third line, they say she was given the scale of midwife and not auxiliary nurse. Whereas she was appointed as an auxiliary nurse and midwife. So, and they say that there was a discrepancy. So they admit there was a discrepancy.
Of what?
In the pay fixation. And query number 2 also makes it very clear. Even the current basic pay of Dalimi Kolita is 51,480. Current pay scale of the similarly other auxiliary nurse and midwife is 68,910. It's almost 18,000 less, my lord. And kindly see serial number 3 at page 35. They say the current pay scale of Srimati Kolita is lower than the other auxiliary nurse and midwife due to her initial pay fixation as a midwife and not auxiliary nurse. Whereas my appointment letter at page 20, my lord. If your lordship kindly sees my appointment letter, it is as auxiliary nurse and midwife. So all throughout.
I'm asking why you have been appointed an auxiliary and midwife, and others appointed auxiliary nurse.
No, I was appointed as an auxiliary nurse and midwife. Now, when I,
Others, page 26 is only auxiliary
no,
nurse.
page 26, my lord will ignore page 26. Your
Then-
lordship will see page 35. Because page 35, it makes a comparison between auxiliary nurse and midwife of the same department. Whereas on one
I
hand,
just wanted to know, you have to be clear.
yes, 26, my
Are
lord,
you
that
saying that this auxiliary nurse and midwife is one and the same post?
as per the ROP at page 41. Page 41, revision of pay, it is midwife oblique auxiliary nurse and ANM means auxiliary nurse and midwife.
Then
So as per the 7th Central Pay Commission and the other pay commission, if your lordship kindly sees, kindly takes up that,
midwife and ANM, oblique ANM.
kindly see the revision of pay rules 2017, my lord.
These are interchangeable or what?
Correct.
Midwife and ANM.
As per their own revision of pay it is, kindly see, my lord.
Sir, I'm asking something and
Well,
you are just traveling unstopped. Yes. This midwife oblique ANM is interchangeable or different post?
As per my understanding, my lord, it is interchangeable
Hmm.
because of the revision of that notification. It does not distinguish between a midwife and auxiliary nurse and midwife. And even if for
No,
arguments,
your understanding why you have been appointed as auxiliary nurse and midwife and others appointed as auxiliary nurse.
no, only one, that page 26 is auxiliary nurse and midwife, but the others have been appointed as auxiliary nurse and midwife.
Then why you have shown this?
Page 35.
That is Archer reply. Appointment I'm saying. Page
Appoint-
26.
Page 26. I have
Auxiliary.
auxiliary life. I have annexed this letter to show before your lordship that a person who has been working as an auxiliary nurse.
I am asking for
Yes.
my understanding whether these are two posts or one post.
Well,
When
as-
you are appointed as auxiliary nurse midwife and others say, for example, page 26.
Page 26.
It's auxiliary nurse only.
Auxiliary nurse. Auxiliary nurse.
So
we will,
according to what is this?
so
Tell us.
So that would mean a person who has been working as an auxiliary nurse has been paid more than a person who has been appointed as an auxiliary nurse and midwife. Because I am not only working as an auxiliary nurse, I am also working as an auxiliary nurse and midwife. So therefore, I could not have been paid lesser pay scale than to this person. And even if for argument's sake we say ignore 26, then also, yep,
So I'm not convinced. Forget about it. Yes.
Well, our stand is that two different posts. She was appointed as an auxiliary nurse and midwife.
Page 41. This ROP. Yes. Then
The appointment happened in 1990, my lord. Whether it has been merged subsequently, that is also not clear.
show us any document that during this 1990-92.
Trace back, my lord, because it was
Yes,
then
you
it-
have to.
then it was AACB, my lord.
When they say that these are one and the same, and they could show that midwife and ANM are either interchangeable or the same pay scale, how you can pay? And why you are saying that the scale of pay of midwife is below the pay scale of auxiliary nurse? From where you are saying?
My lord.
And that will say as per the ROP,
It does not appear to be
page
correct.
35.
Does not appear to be correct.
It's not correct.
Does not appear.
One and the same. Writ petition allowed.
Only thing, my lord, if we go by the judgment of Gupta, which my learned friend has relied, the recovery part will not come. Because lordship will see the fixation is made in the year 1992, the appointment. The grievance is raised for the first time in the year 2020. So even if it is not barred by delay, but there is laches, my lord. Because in 2020, to trace back something which has happened in 1990 is difficult. Because earlier it was the board, Assam State Electricity Board, now it is the APDCL. So had she raised this issue in time, maybe it could have been addressed. Because if your lordship sees the order of rejection at page 31, the ground taken by us is considerable lapse of time.
Not on merit.
Not on merit.
With reference to the subject cited above and the appeal raised by you in the matter of discrepancy in your initial so and so, this is to inform you that the matter was examined thoroughly, but after examining all the facts and circumstances, it is observed that the matter was raised after a considerable lapse of time, that is almost 30 years.
So
Your appointment was.
it appears that you admit that there is a discrepancy. There is a wrong fixation. No, not you. Those authority who has,
Does not say someone.
it indicates.
Does not say.
When you said after examining and all the circumstances, it is observed the matter was raised after a, what does it mean?
Does not say someone. Even in the reply to
When
the
you have
RTI.
considered whether there is a discrepancy or a wrong fixation, right? You could have said so.
It could have said someone. They could have
So it
said.
indicates you just evade.
They have not answered. on
You have
this.
evaded. I mean, your authority.
Only the ground is 30 years delay.
Yes. Therefore, you just have evaded. You could have answered that whether this is wrong or right. And if you said so in the earlier reply, you said that the midwife is a below or the higher, whatever. They could have said so.
Presently, I have checked, my lord, it is A&M,
And,
auxiliary nurse and midwife.
yes. Apart from recurring, how you recurring in the sense, I think in that case, it was 11 years in filing the petition. But what they are saying is your claim is after 30 years.
So, so that is their only, my lord, defense, ground for defense. They are saying
It's a good defense.
it's a good defense. I'm not saying it is not a good defense. All they are saying that the matter is time barred. It is, my lord,
Use the word exactly.
they will, or rather, it is barred by limitation.
Not say,
So-
we say it is barred by delay and laches, my lord. Because
No.
time bar will come so far as the claim for arrear salary, and that has been explained in this judgment, my lord. What relief was granted by the Honorable Supreme Court in this case was
In this regard,
fixation, my lord, no recovery.
Sanjay Kumar Upadhyay. No, this is the latest, my lord, 2025, my lord. Just last month, my lord, last 2 months, my lord. It is not yet reported. Sanjay Kumar Upadhyay versus State of Jharkhand. Paragraph 1 for the facts, my lord. My lord will see, my lord. Arising out of the judgment dated 33/2022 passed in LPA number so and so, wherein the judgment dated 14/12/2011 of the learned single judge in WPC number so and so was set aside by the division bench of the High Court of Karnataka at Ranchi. The present appeal has been preferred by the employee. The dispute between the parties herein relates to the grant of higher pay scale to the employee after removal of anomalies in the pay scale on parity with other similarly situated persons who have been already granted the said benefit by the respondent employer. Exactly the same fact situation, my lord. And my lord will see, kindly see, my lord, the operative portion, my lord. Kindly peruse, my lord, paragraph 32. That is the operative portion. Paragraph 32, last page, my lord. May I just read out, my lord? The plea of delay and lashes cannot be sustained in a case involving continuing violation of rights. That too, in light of the nature of directions issued in REM, the appellant's consistent pursuit of his claim through representations and the timely filing of the writ petition after their rejection, shows that he was not sleeping over his rights. Moreover, facing financial implication and administrative convenience cannot override the constitutional guarantees against arbitrary discrimination. The state, being the model employer, cannot plead its own inefficiency or negligence to deny legitimate rights to its employees, my lord. So, my lord, there's a continuation. So, my lord, every month they pay me a lesser amount than what I ought to have been paid. It gives rise to a fresh cause of action, my lord. And my lord is already aware of this judgment. Jagjit Singh, equal pay for equal work, my lord. Page
Why these
54.
are required?
Just to show one aspect.
Unnecessary, don't but
Just to show that nobody works at a lesser age, lesser wage out of my lord voluntariness.
why? Who is disputing that? Give it back.
They do it because they have to sustain their families. That is the only reason why they work.
Don't travel beyond what is,
My lord.
what is.
I think
not
this
required.
should
What
suffice.
is- More than what is required.
My lord. Oblige, my lord.
Yes.
Para 6 of the judgment relied upon by my learned friend in the case of Gupta, my lord. May I read, my lord? The tribunal misdirected itself when it treated the appellant's claim as one-time action, meaning thereby that it was not continuing wrong based on the recurring cause of action. The claim to be paid the correct salary computed on the basis of proper pay fixation is a right which subsists during the entire tenure of the service and can be exercised at the time of each payment of the salary when the employee is entitled to salary computed correctly in accordance with the rules. This right of the government servant to be paid the correct salary throughout this tenure according to computation made in accordance with the rules is akin to a right of redemption. I'm sorry, my lord, not paragraph 6, paragraph 5, my lord. What it says that the recovery shall be limited to a period of would be barred by time, my lord. And it has been explained in Tarsim Singh that the recovery of area salary, if it is held that it is wrongly fixed, my lord, would be limited to 3 years. Tarsim Singh, citation to Basan.
Where is Tarsim Singh?
I'm giving the citation, my lord. Judgment of 2008, my lord.
Recovery means what?
The arrears, my lord, if he claims arrears, arrears will be limited, my lord, from the date when he has raised the claim, it will be limited to the 3 years prior date. He cannot claim arrears of pay from 1990, my lord, even if your lordship finds that fixation was wrongly done in 1990, my lord. Because para 5 is clear, my lord. It is no doubt true that if the appellant's claim is found correct on merits, he would be entitled to be paid according to the properly fixed pay scale in the future. And the question of limitation would arise for recovery of the arrears of the past period. In other words, the appellant's claim, if any, for recovery of arrears calculated on the basis of difference in the pay, which has become time barred, would not be recoverable. But he would be entitled to proper fixation of his pay in accordance with rules and to cessation of a continuing wrong if on merits his claim is justified. Similarly, any other consequential relief claimed by him, such as promotion, etc., would also be subject to the defense of laches, etc., to disentitle him to those reliefs. So what the apex court has held that he is entitled, he may be entitled to the proper fixation and recovery to the extent which is not barred by limitation. Lordship knows the period of limitation for claiming any relief is 3 years, madam, which has been explained in Tarsim Singh, madam. Citation 2008? 648.
Extra copy as an extra matter. 3 years from the date of demand.
3 years from the date of demand. Para 6 of the judgment. In this case, the delay of 16 years would affect the consequential claim of arrears. The High Court was not justified in directing payment of arrears relating to 16 years and that too with interest. It ought to have restricted the relief relating to arrears to only 3 years before the date of writ petition.
Where you are reading?
Para 6 of the judgment, madam.
They have relied Amar Gupta also. Amar Gupta has been considered.
Yes, Amar Gupta has been done.
The High Court was not just been direct payment areas relating to 16 and the two would respect it ought to have restricted relief relating to areas to date of writ petition from the date of demand to the whichever was lesser. Ought not to have been granted interest in the areas in such. What is the this is only for areas?
My lord, it is
Only for arrears.
3 years from the date of filing of the writ petition or date of first demand, whichever is lesser.
It's 2020. Demand is 2020.
2020.
21. Now she has retired.
No, she's about to retire.
Yes, that's all. Heard Mr.
A.K. Borua, madam.
A.K. Barua,
A.K. Borua.
learned counsel for the petitioner. And also heard Mr.
And like,
N. Deka, learned standing counsel, APDCL for respondents. What would be the
So, that's undertaken.
scale of pay?
Scale of pay, as per the latest, my lord, RTI reply, kindly come to my lord, page 35.
That is basic pay.
That is the basic pay. It should be, as on 2022, it should have been 68,910. That should have been the basic pay. But now it is 2026.
rather than not specifying what is the exact scale of pay, my submission is that let it be remanded to the authorities to fix the scale at the scale of the present scale of ANM. Let them redetermine it.
Yes.
That will resolve the issue.
As the similarly situated persons are
Yes.
getting in the post of auxiliary nurse and midwife.
It's like a body too. 2022.
Confusion. Let them fix this.
The agreed by the grant of lesser pay scale to the petitioner. In the post of auxiliary nurse and midwife.
Midwife, ANM.
Within bracket, and this present petition has been instituted. List of the petitioner has also challenges the, where is that order?
My lord, that order, my lord, page 31. This is the impugn order.
Communication dated 01/02/2022 issued by the Chief General Manager within bracket HRA bracket close APDCL, whereby the claim of the petitioner as regard discrepancy in initial pay fixation has been rejected on the ground that rejected being raised after a considerable lapse of time, i.e. after almost 30 years after the from the date of appointment of the petitioner. Thereby rejecting the refixation, claim for refixation of pay. Next paragraph. The petitioner was appointed as auxiliary nurse and midwife within which AM in the Earthwell Assam State Electricity Board.
Presently known as APDCL.
Electricity Board. In the scale of pay of rupees 1025-35-1375-EB-40-16 55 plus other allowances. You take it from page 20, page 90, 18, huh? Page 18, huh? This page, this thing. Scale of pay, huh? Page 19, 18, sorry. This is the type copy. On, sorry, huh? On 29/04/1992. The petitioner was last posted on 05/10/2018 to the establishment under the Chief Medical Officer, Mama APDC at Bijli Bhavan. Wherein the petitioner is presently serving. You are still working
Still working, my lord. As on that working.
from 2018.
Yes, my lord. In the same Bijuli Bhavan.
Next paragraph. It is the contention of the contention of the petitioner that she came to learn that there is a discrepancy in her pay scale for which she approached the responding authorities for redressal of her grievances. Good stuff. The other, where is this page 26?
Page 26, my lord.
Are you
So,
relying?
that is not very relevant.
No, it provides a higher pay scale.
Yes.
From where he is drawing parity, my lord. 26 is relevant because 26 is saying that similarly situated person was appointed in a higher scale.
Is the similarly situated auxiliary nurse and midwives have been provided the pay scale of rupees 1085 dash that thing, huh? Page 26. 40 so and so so and so. Per month plus all other allowances. List of. And you represented.
I represented page 29 and 30.
The petitioner contains that one Srimati Rukomati Masari, who was appointed on 21/06/1990, earlier than the petitioner, has been provided the higher pay scale than the petitioner, whose appointment was made on who has been appointed on 29/04/1992. Next paragraph. The petitioner filed a representations on 21/02/2020 and 27/07/2021 before the respondent authorities for providing for grant of a similar pay scale as that of the other auxiliary nurse and midwives who are being paid a higher pay scale than the petitioner. By communication dated 01/02/2022, the Chief General Manager, it's within bracket HRA, APDSL, has informed the petitioner that the discrepancy in the pay fixation as raised by the petitioner cannot be entertained as the same was raised after a considerable lapse of time. After a lapse of considerable period of time, thereby rejecting the claim of the petitioner. Mr. So-and-so Borua,
Borua, my lord.
learned
A.K. Borua.
counsel for the petitioner while referring to the documents annexed in the writ petition submits that there is no dispute regarding the post of auxiliary nurse and midwife as the midwife and auxiliary nurse are one and the same, having the same pay scale. However, the petitioner has been denied the same pay scale with that of other auxiliary nurse and midwife who has been provided with a higher pay scale than the petitioner. He submits that although the respondent by way of RTA reply has stated that the pay scale of midwife is below the pay scale of auxiliary nurse as per the ROP. There is nothing on record to show that the skill pay of so that midwife and the auxiliary nurse are two different posts having a different pay scale. The respondents have admitted clearly that the petitioner is appointed as auxiliary nurse and midwife within bracket ANM. The respondent authorities have also clearly provided the basic pay of the petitioner as rupees 51,480 and the basic pay of other similarly situated ANM as rupees 68,910 which clearly reflects the discrepancies of discrepancy of pay granted to the pay being drawn by the petitioner and other similarly A&M. The it is further admitted by the respondent authorities that the current pay scale of the petitioner is lower than the other A&M due to her initial pay fixation as per her appointment order dated 29/04/1992. Next paragraph. Mr. Borwa, learned counsel, further, while referring to the, where is that ROP? This is ROP.
That ROP is there, my lord.
Copy
Page number 41, my lord.
ROP. And submits that the ROP clearly provides the post of midwife public A&M as one and the same, and provides the same pay band, comma, grade pay, same pay band and grade pay, which clearly indicates that there cannot be any distinction between midwife and A&M as the same as the A&M is an auxiliary nurse and midwife. Therefore, he submits that respondent authorities may be directed to provide the same pay scale and other admissible allowances to the petitioner with that of the similarly situated auxiliary nurse and midwives. That's all.
That's all.
Yes, then Mr. N. Deka, London Standing Counsel for APDCL for the respondents. Firstly, fairly and firstly submits that the what is that RTI reply?
Page 35.
RTI reply shown to have been given by the authorities appears to be not correct in the facts and circumstances. It's not correct.
It's not there is no adjudication or reply given on merits, man.
Before that,
Lordship,
RTI, you said so.
I'm not saying so. I'm saying that it has not adjudicated, nothing has been said on merits of the case. The rejection is solely on the ground of delay.
Okay, submits that. Submits that, the communication, the impugned communication dated 01/02/2022 issued by the Chief General Manager HRA APDCL appears to be on the basis of delay and laches, as the petitioner admittedly raised his grievance after lapse of 30 years from the date of her appointment on 29/04/1992. Admittedly, it appears that the matter has not been considered on merit, right? Therefore, he submits that if since the petitioner has slept over her right for last 30 years, he would not be entitled to any relief. He will not be, he is debarred from claiming any grievance after a lapse of many years. However, he submits that matter can be remanded back to the respondent authorities to reconsider, reconsider the claim of the petitioner on merit. On merit. That's all.
That is
That is his submission. Do you want that I should not record his submission?
No, your lordship.
Then, consider the submissions, I've considered the submissions of land council for the parties. And also, and I have perused the materials available on record. Next paragraph. The petitioner was appointed as auxiliary nurse and midwife in the Assam State Electricity Board dispensary, electricity board, which now, within bracket, now APDCL, bracket close. We'll say the APDCL, now APDCL within bracket, Please stop. The scale of pay as per the appointment order dated 29/04/1992 of the petitioner is reflected as rupees, has been shown as rupees 10 so and so, page 18. List of the other similarly ANM who has been appointed on 21/06/1990 has been provided the scale of pay of rupees 1085 so and so. Page 26, which is higher than the pay scale of the petitioner. List of the next perusal of the ROP. Where is that ROP? This is which ROP?
Well, this is 2017. I have a copy, my lord.
Just keep it. ROP.
ROP.
The Assam, what is called? Revision.
Assam Services Revision of Pay Rules 2017, my lord.
Some revision of so and so. You just write it. 2017. Reflects the midwife oblique ANM has the same pay band and pay grade as PB-2 space 5200-20-20200, then 2400, then PB-21400-490. This, Mark one. You just see that. Upon consideration, it cannot be said that the midwife oblique ANM are two different posts having a different pay scale. Rather, it clearly reflects that midwife oblique ANM are one and the same post having the same pay scale and having same pay scale, oblique grade pay. List of. Next para. As submitted by the learned counsel for the respondent, Mr. Decker, that the respondent authority appears to have considered and examined the matter not on merits, however, appears to have rejected the grievance of the petitioner only on the ground of delay and laches, as the petitioner has raised her grievance as regards the discrepancy in pay scale after the lapse of almost 30 years from the date of her appointment. Mr.
2020 minus 1992 to
Mr. Having considered that the respondent authorities have not considered the grievance of the petitioner on its on merit, comma. I am of the considered view that same is required to be considered on merit, ignoring the said delay, in view of the fact that there appears to be a clear discrepancy in fixing the pay scale, in fixation of the pay scale, maybe inadvertently at the time of initial appointment of the petitioner, as is supported from the documents, as is supported from the records, including the ROP 2017 listed. Next para. Regarding head to the delay in raising the grievance, comma, Mr. So-and-so Bora, learned counsel for the petitioner, and has relied upon the judgment of the Honorable Supreme Court. In the case of, what is this?
First is MR Gupta versus Union of India.
We'll just rely only one.
And my lord will take the latest one, my lord. Sanjay Kumar Upadhyay, 2025.
No, we'll just MR Gupta versus Union of India. Reported in
my lord 1995 5 SCC 628.
1995
5 SCC 628.
5 SCC 628. Para?
Para, my lord, 5, my lord.
Relevant paragraph, which is before this hidden bill. Para 5.
This one, my lord, latest one, my lord. Sanjay Upadhyay.
It's okay. This has been relied, MR has been relied. He also, next para, Mr. Barua has also placed reliance on the judgment of the Honorable Supreme Court in the case of Sanjay Kumar Upadhyay
versus State of Jharkhand.
What is State of Jharkhand? Reported in?
Well, it is not reported yet. It's a very latest one, my lord.
You just said decided on 16/12/2025. We'll find out, huh? I'll give you the citation.
Para 32.
Whereby the relevant paragraph, which is para
32, my lord.
Is reported in para 32, huh? Then division bench. No.
Division bench, my lord, Chandika Kaur.
This is
Paragraph
also-
7, my lord.
This is
Property
relied on the.
Same, MR, it has been relied by a division bench. Paragraph 7, my lord. Local judgment.
Next para. Next para, huh? On perusal of the aforesaid judgment, and on perusal of the aforesaid judgments of the Honorable Supreme Court, comma, I am of the view that there would not be any quarrel to the aforesaid judgment, although it has been rendered on the circumstances of those cases as any recurring oblique continuing, continuing oblique recurring cause of action, comma, no application can be brought on the ground of limitation. Nevertheless, since no, please stop. In the present case, records and the provisions of the law clearly fortify the grounds of the petitioner as regards the discrepancy in fixation of pay scale, and admittedly providing she is being provided with lesser pay than the other similarly A&M auxiliary nurse midwives in the same under the same authorities, i.e. IPDCL, comma, the petitioner, in my view, would be entitled to be provided with the similar pay and allowances as granted to the other similarly auxiliary nurse and midwives under the same authority, Mr. Under the respondent authorities, huh? Mr. That's all. That's all.
Not directing any recovery or area, because if areas, then it is to be limited to
We'll
3
limit it 3 years. We'll provide that.
No, from the, as per Tarsem, from the date of demand.
In view of what has been discussed here in above, in view of what has been discussed here in above, come on, I want to consider view that there exists a discrepancy as regard to pay fixation with regard to the in respect of the petitioner. Thus would be appropriate to direct the respondent authorities to consider and refix the pay and allowances of the petitioner as that of the other similarly situated A&M of the APDCL. This stuff. It is provided that, where is that out?
Mal- Tarsem, kindly have this one, Tarsem.
Okay. Para?
Para, my lord, para 5.
para 9, para 8.
Para 9 or 8? Where is it?
In that, my lord, hard copy, paragraph 5.
Tarsem Singh.
6, sorry, I'm sorry. Paragraph 6.
Paragraph starting with in this case.
The delay,
It is provided that,
my lord. So 3 years from the prior from the date of demand.
No, no. It is provided, huh? The claim for areas, huh? Stephen, the claim for areas of the petitioner be restricted, we'll say, restricted to 3 years from the
Date of demand.
date of demand,
That is 21 to 2020.
i.e. 21 to 2020.
3 years prior, that would mean
Ah.
21 to 2017.
Then we'll say the restricted to 3 years prior to the date of demand or restricted to 3 years, right?
Date of demand.
i.e. 21
21 to 2020. That is the
To-
first time she gave a representation.
2020, right? Don't, because this is not on record. It's on record.
It's on record. That even rejection, kindly see page 31, they reject,
Ah.
that it is referred. Page 31, my lord.
Page 31,
Your
date of
application,
demand,
date of demand,
Demand is at page 29 of the.
As
29,
no, just wait.
29 is the first date of demand.
As observed by the Honorable Supreme Court, continue in the, last one. You continue as observed by the Honorable Supreme Court in the case of Union of India versus Tarsem Singh,
Percentage.
reported in 2008
8 SCC 648.
SCC 648. Late petition is stands. Say allowed and disposed of
Allowed and disposed.
accordingly.
My lord, your lordship will kindly fix a time period, my lord.
For what?
For expeditiously, my lord, completing the entire exercise, my lord.
Then we say
30 days, ma'am.
expeditiously,
60 days.
30 days.
60 days. 60 days.
expeditiously, but not later than
60
not
days.
60 days.
60 days.
Okay.
Obliged.
Huh?
Deeply obliged. Deeply obliged.
You give it to him. Take this horse.
Obliged.
Judgments are here.
Item 14.
Sorry. So much. Yes, sir.
Well, this matter was earlier heard and then judgment was reserved. But
Who? This court?
No, by another bench. The honorable judge couldn't deliver the judgment and got transferred. Now it was released thereafter the matter has come up. But it on to last occasion, the court said that because the lawyer who was representing the other side has been elevated. So
Okay.
he could not take up.
So what is to be
Now,
done? now?
now it is to be, what I find that education department, health department are involved.
Yes. Who else are appearing?
For elementary education, I appear.
Mm.
Counsel for the health would be necessary.
So some other day, that means. What do you want to say? It's some other day.
Yeah, it will be fixed on a date so that they will come organize.
As agreed to by learned
Huh? What?
Senior Counsel, Mr. K.K. Mahanta,
Huh?
assisted by
Oh.
assisted by M.S.
And big.
N. Begum, learned counsel for the petitioners,
Yes.
and Mr. S.K. Talukdar, learned standing counsel for elementary. Elementary, let this matter be listed after 3 weeks.
No, Malad, it will be too late because better of 2022, they are all waiting for appointment.
We are dealing with still 2014.
True, Malad, these are.
Take it 2 weeks.
In
that
A
no
date may be, Malad, 2 weeks, a date may be given on a hearing date so that it can be taken up because it will definitely take some time.
So we'll make it 3 weeks and give you a date, fix that.
Malad,
Because why I'm saying,
I can
reason
take
reason is
yes,
we pick so many matters
that's true.
within, after 2 weeks, right? So it's not be humanly possible to take up all the matters
True, Malad.
after 2 weeks. So we'll give you a fixed date after 2 weeks, 3 weeks. If not, we'll give you a, if you fix it after 2 weeks, no fixed date. Because we have fixed so many matters earlier. That's the reason. Otherwise, no, there's no issue for me fixing that.
At your lordship's convenience,
let the
fix that be there.
Huh.
Let a fix that be there.
Huh.
So that
after
everybody
3
will
weeks.
know.
Huh.
10th March, ঠিক আছে? Finally? Huh? Good night.
10th March.
10th March.
Yes.
হবো? 10th March Tuesday, yes.
Yes.
My lord,
Matter has become infructuous.
not in practice, my lord.
Then,
My lord, in view of the, my lord, division bench order,
huh.
my lord, the petitioner is entitled for, my lord, appointment
What
on
appointment?
compulsory ground.
My lord, similar matter, my lord has taken up yesterday, two matters.
Huh. Today also.
My lord, the division bench judgment, lordship kindly see.
Of what?
The, my lord, only, my lord, clause has been challenged before the, my lord, single bench. And single bench, my lord, was pleased to set aside the clause. That was went to the division bench, and division bench affirmed the order passed by the honorable single bench.
My lord will.
So we are entitled.
My lord will see para 22.
While making such application before the concern, the primary respondents will make a question must not entertain any false hopes standing. Also shall consider the process of time, expect seriously while assessing the suitability of private respondent for resident opponent, which should be the most important factor in recommending the case, which ultimately may not withstand the judicial scrutiny if such recommendation is made after a long lapse of time. With the opposition, they will close the appeals day of the statutory authority while concerning case of the apply the law with regard to compensatory problem. This is when?
Yes.
This is when it was disposed of?
Was dispose of, my lord, decision. No. You shut up, boys.
This is
12/12/2025.
My lord will take up this matter after some time, my lord. At 2 o'clock, we will also give some judgment. After this, my lord, the coordinated bench has passed few orders, my lord.
So whether this office memorandum
That
of
clause,
2024 has been taken into account? Here?
2015, my lord, clause.
My lord, that is gone now. Now 2024, they haven't challenged.
Lordship kindly see, my lord, para 21. Para 21 of the judgment.
We does affirm the relegating order passed by the learned single judge.
Yes.
So,
The single judge was pleased to set aside the clause saying that the balance service should be 3 years. That has been interpreted by the single bench, and that has been upheld by the division bench.
no, problem is thereafter,
Yes,
thereafter, there is a subsequent development,
my lord.
which we have allowed today also, yesterday also, to file an appropriate, to withdraw the present application
Right.
and with the liberty to file afresh. This can also, you can raise all this thing
Yes.
when you file the fresh petition challenging that subsequent development, I mean the office memorandum.
Now, in that case, my lord,
Yes, we'll allow you to withdraw to file afresh, then you think about it. Because I cannot have a different view.
now we have challenged the, my lord, important decision given by
You,
the, my lord,
yes,
SLC.
including,
Yes.
you can challenge that same thing. That's why we're giving a liberty. Your hurdles is OM 2024.
Yes.
You challenge that, work it out.
Now let them produce the judgment, my lord, I will see.
No, no,
Otherwise,
no. I have already, yesterday also similar.
yes.
2-3 matters yesterday, today also one matter.
Now then,
We're
in-
granting you withdraw this present petition, granting liberty to file afresh. Challenging everything, every consequent, I mean subsequent order,
now in
including
my
this.
case, my lord, SLC has rejected my case.
I know that. Same
That has
thing.
been challenged.
Heard Mr. M.U. Mandal, M.U. Mandal,
M.U. Mandal.
Learned Counsel for the petitioner, who submits that in view of the subsequent development, including the coming into force of Office memorandum dated
18 September 24.
18/09/2024. He may be allowed to withdraw this writ petition with the liberty to file afresh. Liberty to file afresh.
Yes.
Mr. R. the Learned Counsel for the Learned Standing Counsel and A. Celia. Are present. Prayer for Udalil accepted. Accordingly, writ petition stand closed is withdrawn with the liberty to file afresh. Right? You club everything and file, we'll see, including relying this judgment too.
My lord, in case of item 25, my lord,
Same.
similar order may be passed. my lord.
Okay. Mr.
M.H. Rajbarbuya.
MS Raj Barbuya. Same order. Okay. Yes.
In this case, what happened, my lord? They are working long back, my lord. Earlier government, they have made to appoint, my lord. But last occasion, they have they have issued a notification that they will not comply with the earlier government, my lord. They are not bound to comply, my lord. Then I approached this honorable court, and this honorable court, your lordship has passed an order that is status quo as on today. Now, today, my lord, she has some sort of documents, my lord. That's why she needs some time. So a short maybe that may be fixed, my lord.
What is the IA is all about? What?
IA for against the, they have made advertisement, my lord. Lordship, kindly take up the matter 667. First. They have made advertisement, my lord. That is page 45. In this case, my lord, there are 145 candidates are there, my lord. They are all working honorary, my lord, dropped as a gate 4 and gate 3, my lord. Half of the persons were.
Yes, what is your instruction?
Receive up-to-date instructions, my lord. These are of 2025, my lord. So we'll take updated instructions regarding this.
And I have to supply some copies.
Yes,
of
my lord.
some
In
copies
item
are
number
short.
17, 18 and 19, my lord. We need.
Heard MS K. Devi Learned Counsel for the
Hey.
petitioners.
You have already made PDF.
On the prayer of
Give it to Aaron.
Mr. MS
B. Bora.
For
or
BTC.
BTC.
Yes.
You are also one. You are also often BTC. Understanding of
No, no,
BTC.
secondary department, Assam government of
This matter after 3 weeks so as to enable her to
Let's
obtain
kindly
instruction.
fix a date, my lord. Fix a date.
MS K. Devi to furnish a copy of some of the writ petitions
Yes.
to the Learned Counsel.
My lord, status quo as in.
BTC. MS so and so is present. List
My
of
lord, earlier order
Three-
may kindly be.
team order pass
Yes.
will continue. Yes.
Shall be
next.
continued. My lord, date may be fixed, my lord. Otherwise,
Why?
no, otherwise case will not be listed. Again, I have to mention before the register, my lord.
Mention it.
Very
It's not
difficult, my
listed.
lord. If your lordship kindly, my lord, fix a date then.
You wanted it should be, you wanted,
My
no,
lordship fix
no
the
select, no,
unfettered date.
no, no, no selection shall be made. You want your post to be regularized.
Regularized
You
because,
don't want the state should fill up it by way of selection process.
no, that is not case, my lord.
What is your
This
case?
case is, my lord, they have been working before.
That is understand what you want. You have not been
Regularized,
regularized. So you want the regularization.
Yes, yes.
You want the vacant post should not be filled up by
Yes, yes,
selection
yes,
process.
yes.
How can it be? We'll direct them to fill up
No, 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 my lord, not
including
that
you may
vacant post is our vacant post, my
How
lord.
can you say that?
Because they have applied SIU approval.
How you have been appointed?
We have been appointed 94, 92.
How?
As a draw before provincialization of the school, my lord.
How?
By the
Any se-
managing committee, my lord.
Any selection process?
No.
Or pick and choose?
No, no, not pick and choose, my
Then
lord. This
any
is
selection
by-
process?
In my lord, in non-provincialized school, managing committee has been appointed actually.
So
After
managing
provincialized,
committee
someone is dropped, my lord. Then the government took them by as a vacant post when arises, my lord. That is my case, my lord. And government took
what is the rule? As in when vacancy?
government took government took
Government has taken a resolution of decision.
there.
So
My lord,
to
cabinet decision is
to
there.
regularize your service,
Yes, my lord.
then go to the government cabinet.
No, 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 I have to obtain some order from this.
No. When the government has taken a decision, you go to the cabinet, request them.
Because some of the
Otherwise, madam,
my lord, similarly
otherwise,
situated person have
with-
already been regularized.
how? Under which provision?
If similarly situated person have been regularized,
No.
so I may be also regularized. There is a Supreme Court order, my
No.
lord. I'll show. my
There is a
lord.
Supreme Court order against you. Not in your favor.
Oblige you, lord.
Yes.
Lordship, matter may be passed over for the time.
What Passover? What is the matter?
Matter pertains to lordship regarding the holding of insertship lordship. The petitioner assailed the order by which I was allowed to hold the charge. And that order was issued in terms of the court's order. But according to them, lordship, although there is a direction, this order is passed lordship 10th of April 2023 in violation of the honorable court's order, lordship. Lordship, may kindly come to page 85. Was the order 28th of 7, 2022
By whom?
by this honorable court.
Direction
is given to director, page 87. Till the accordingly matter, paragraph 5, accordingly the matter is remanded back to the director of secondary education to decide afresh by taking into consideration rule 14.2 of the rules of 2018. Thereafter pass appropriate order
1 month
within
from the
period
date
of 1 month.
copy of
Till the director of so makes a final decision within the said period of 1 month, respondent number 5 so may be permitted to hold the charge. Now, in compliance of this order, Lordship may kindly come to page 91, annexure 22, which is put with
So
the
he was Jahangir Sheikh was allowed to hold the charge.
check.
Huh?
I am representing Jahangir Sheikh, respondent number 5, page 91.
Hmm.
According to them, page 93. 11th of April.
Jahangir Sheikh is hereby allowed to hold the charge of headmaster of the same school along with principal. Yes.
This order allowing me to hold the charge. According to them, this order is not in the tune of the earlier court's order. That is why they have put to challenge.
What is earlier court order?
Court's order is the 28th of 7, 2022. According to them, let's say they have not taken into consideration the director while issuing this impugned order, according to the petitioner, as claimed in this writ petition, that without following the rules of 2018, the director has issued this impugned order, 11th of April 2022.
28/7.
But admitted fact is that, Lordship, both the petitioner as well as the respondent number 5, they are not eligible to hold the post. That is why, Lordship, direction is given to the director to make a.
What director has been, what action has been taken?
That order is 11th of April 2023.
Where it is?
Page 93, annexure 24.
No. What is this? This is a temporary order will come into. No, para 5.
Yes, accordingly.
You decide afresh by taking into consideration and they have passed approval order within a period of 1 month from the date of receipt of copy of this order.
That order is not, yes, apparently not issued.
Then how you can be continued to allow?
No. So Lordship, what I am also thinking that Lordship will again remand back the matter.
No, no, why it should really be? Why is saying it's in violation of this?
My senior is court number 4, sir.
Obtain instruction. Why director has not been taking? Heard Mr. So-and-so learn counsel for the petitioner. And Mr. So-and-so learn for respondent number 5. 2 weeks time is granted to Miss MS. Esther Angpil learned standing counsel. Secondary school to obtain instruction. Yes. Next.
Lordship will fix a date, Lordship.
We'll
Because
see. You are
now,
working now.
in spite of what happened, Lordship, there is the interim order is operating.
Hmm.
Although I file IA to vacate the interim order, Lordship, against this Lordship
Let
order.
them 2 weeks, we'll see.
After 2 weeks, any date, Lordship. Otherwise, Lordship, he is holding the charge.
Huh?
Now he is holding the charge.
Okay.
In spite of Lordship order.
It's okay, we'll see.
After 2 weeks, any date, Lordship.
If both of you are not eligible, forget it.
No, after 11.
You said that both of you are not eligible.
That is why, but I am the senior most teacher of this school. That is why.
Still then you are not eligible.
Otherwise, also, I am also not eligible. Petitioner also not eligible. I am also not eligible. But what a minute, kindly for a minute.
Sir, 2 weeks, we'll see.
That is why, Lordship, the senior most teacher till the fresh order is passed by the director.
What is the rule?
Lordship,
What is the rule?
Rule 14(2), Lordship.
What is this?
It says that, Lordship, 10 years of minimum
You
qualifying
have
service.
completed 10
I
years.
am having qualifying of 10 years of service, but so far the petitioner is concerned, he has not completed 10 years of qualifying service.
Then why you
That
said you are?
count, on that count, he is not eligible. But so far, me, Lordship, I am not having the B.Ed qualification. That is why, Lordship, I am not.
It has to be B.Ed,
So
10
that is why
years and
Lordship-
B.Ed.
Lordship, we fix a date, Lordship, any date, Lordship, after 2 weeks, any date.
Give the date.
March. Looking. Oblige, Lordship.
Yes.
Lordship, petitioner case was considered under the Assam Public Service Appointment of Family Members of Persons Killed by Extremist Terrorist Rules 1992 for appointment, Lordship. His father was killed by extremist, Lordship, in the year 2002, Lordship, 25/11/2002. And the DLC, Lordship, has considered the case of the petitioner on 14/6/2016. For appointment of the petitioner under Gate 4 post, Lordship. The DLC minutes, Lordship, is at page 91 in my additional affidavit, Lordship. Page 91, Lordship.
What do you want?
Lordship, I want appointment, Lordship.
How? Under what provision?
Under the Lordship 1992 rules,
I think rules is no longer there.
no longer there, but later on, Lordship, by virtue of the judgment of this honorable court, Lordship, where says that 1992 rules will be applicable wherever the application received prior to 2004. And Lordship, my application for appointment under these rules was made before 2004, Lordship, the cutoff date. The cutoff date was 22/4/2024, Lordship, 2004, Lordship. And once I was considered, Lordship, and they have to give appointment, Lordship. Now, this writ petition was filed assailing the order of 11/5/2023 passed by the Lordship Finance Department. Where it says that I have already got 3 lakhs rupees as ex gratia. So therefore, the Institute of Proposing and any other fund able as per stable norms, government, the petitioner instead of that I will not be eligible to get any appointment, Lordship. They are staying, Lordship. And by virtue of the Lordship full bench judgment in Dhaneshwar donation last Lordship, there says that these rules, though appeal, these rules will apply, Lordship.
Heard Mr. So-and-so, learned counsel for the petition and Miss MS has agreed to well learned counsel for the party that this matter will be listed after 3 weeks. I'm not getting any head and tail. 3 weeks.
Any short date, Lordship?
Huh?
Any short date, Lordship?
2 weeks. Yes, Bora.
Yes, Lordship. Lordship, here pleadings are complete. Lordship, may I fix it any date for admission hearing? Lordship?
This is admission hearing only. This is admission hearing only.
Yes, Lordship.
This is admission hearing
Yes,
only.
yes, Lordship. I am led by senior counsel.
Then say no. Mr. BP Bora, learned counsel for the petition established that matter may be listed after 3 weeks. As the leading counsel.
Pleading is complete, my lord, if it is.
Lordship, admit.
Cause
Lordship,
my lord has to admit it then.
Lordship
Pleading
will take
complete, that
time.
is his submission, not mine, my lord.
Led by senior counsel who is stated to reportedly, he was stated to be indisposed. Mr. Arthur Lang, state counsel is list after 3 weeks. As prayed for, huh?
Matter regarding Lordship, non-consideration of the promotion to the post of Assistant Executive Engineer. In spite of existing 10 numbers of vacancies.
Any affidavit?
No, Lordship.
Yes.
Urban,
Urban.
yes,
Hard MS.
urban affairs,
Huh?
housing and urban affairs.
Housing.
I am looking to respond. Prime respondent is my friend.
Huh? Affidavit, no.
Yes, Lordship, we require some time.
MS so learned counsel on the prayer of Mr. RM Das.
SP Chaudhary, Lordship.
SP Chaudhary, learned counsel for the standing council.
Yes,
Urban?
urban and water supply sewerage.
Urban and water supply. Assam Urban and Water Supply Sewage
Board.
Board. What is it? For the 3 weeks time is granted to file affidavit. Mr. You have filed? You don't know to file?
Respondent one. Probably party.
The signature there.
Respond number 1,
One.
standing council. Of what? Standing council, housing and urban development.
And urban.
Urban, yes. Yes,
32 and 33 similar matter, Lordship.
same order.
College.
That one is over.
May I please, Lordship?
Yes.
My lord, kindly see, my lord, page 27.
What is this?
My lord, limited prayer. My husband was a my lord employee who died, but his salary has not been paid till date. My lord, kindly see page 27, my lord. Page 27 is my representation, my lord.
Assistant teacher of Durgapur, so who died and yes, affidavit. Why they are not paying?
No affidavit has been filed, my lord.
Yes. Who is for the respondent? Who has to pay?
My lord, education, my lord, elementary department.
Elementary.
Elementary.
Can the matter be taken up to some?
No, no. You need to file an affidavit. You have to respond. Or
No.
Mr. M.U. Mandal,
May I
learned
pray,
counsel
Milord?
for the petitioner. Okay, it's okay.
No, the authority will deal with the, if the provincialist teacher. No, my lord, may I pray, my lord, let them dispose of my representation within a time specific period, my lord. That will suffice my case, my lord. Otherwise, lady who has
We just wanted to know. what's
without
the-
salary.
Huh? So what do you say? What do you want to say, madam? Time being.
Timing.
We'll grant them some time to respond.
My lord.
Heard Mr. M.U. Mandal, learned counsel for the petitioner. On the prayer of MS, does learned counsel appearing on behalf of Mr. S.K. Talukdar, learned standing counsel, education. What elementary education? Further 3 weeks time is granted to file response.
Can it be, my lord, 2 weeks, my lord?
3 weeks, they will not file.
My lord, since 23, my lord, lady is without salary, my lord.
We'll see.
And he has no any source of income. Husband died, but his salary has not been paid.
Yes, we'll consider.
Allah is Lord.
May I please your lordship? Lordship, my senior has left due to some personal difficulty. Can the matter be passed over for delay, Lordship?
Yes, any instruction?
No, we have already filed our affidavit, your lordship.
Saying what? Excess payment, recovery, you have recovered. Huh?
Not yet, your lordship.
So he was allowed to draw the pay of UDA. Huh? For how many days? How many months? Or MS so and so learned counsel appearing on behalf of Mr.
M.U. Mahmood.
M.U. Mandal, learned counsel for the petitioner. As prayed for, place this matter after 2 weeks. 3 weeks.
Deeply obliged.
36, 37.
Lordship, otherwise pleadings complete. Lordship, petitioner told me that he is in court number 10, so maybe taken up after some time, Lordship.
What is the matter?
Firstly appointed in CRPF, then subsequently on verification, we found that he applied as an OBC and the Bishnupriya Manipuri. But then on verification, we came to know that Bishnupriya Manipuri is not in the list of central list of OBC in state of Assam. So we his services. Being aggrieved, he had filed this writ petition. And our stand has been cleared by the WPT and BC Department Government of Assam.
Other two, why two petitions? 2 persons.
Relief.
It is submitted that
কিবা দুৰ্বল নেকি ডিপাৰ্টমেণ্টে মোৰ তাত নাই কিবা পিছৰ ৰেকৰ্ডটো চাওক আপুনি
petitioners is on the legs in some other court. Viewable.
মই পাইছো
MS so and so. CGC. That is CGC, is it? Viewable. That this matter listed after 2 weeks. Record is there.
item number 37
Record the number, huh?
The affidavit has not been filed. The matter is getting listed repeatedly. If matter is getting repeatedly but not 38. Not being, affidavit not filed by the state, right?
Yes, is that
Principal of the college file. Well, that may be because once they take 2 weeks time, it get listed after 6 months, that too from my representation, after my application. They are taking 2 weeks time repeatedly. Then after 4 months, I file an application, the matter gets listed. Lordship, kindly peruse the last orders. In each and every occasion, I submitted application, then matter getting listed and they are taking 2 weeks time.
you got it listed by filing application?
Yes, yes. And they are taking 2 weeks time in each and every occasion. Very unfortunate.
Okay.
Lordship may guide it, but a last chance, otherwise my lord, on the basis of this matter be disposed.
What is the matter?
Matter is regarding the petitioner got selected for a process of selection advertisement to the post of assistant professor of the GC College Bengali. Assistant professor. She got selected for the post of assistant professor, Bengali department. But this, it has been cancelled. So my lord, on the first day of order, lordship, it has been stayed. Cancellation has been stayed. On the ground that they have, it is re-advertisement. Ground is that because she appeared after advertisement, she is the sole candidate.
Okay, heard Mr.
Yes, not.
S. Nathan, counsel for the petition. And also heard Mr. S. Dattalan, senior counsel, who submits that he has filed the affidavit on behalf of respondent number
4.
Mr. S. Das Kukon. S. Das Learned Standing Council, Higher Education is granted for the 2 weeks time to file affidavit.
Interim to continue.
Interim or the.
Obliged.
Continue. Personal yes.
A date may be fixed, my lord.
We'll see after 2 weeks.
Well, in this case, the respondent will be asked to clarify on their affidavit, because this affidavit is not really comprehensive. It has only dealt with one aspect of the matter. In fact, that is what we had already submitted before this honorable court. Paragraph 5, my lord. So
In
clarification.
that
was-
regard, Lordship, I have received my instructions yesterday, Your Lordship, wherein it says that we have submitted a proposal on additional financial implications in respect of upgradations of grade pay for the vocational teachers as per the 7th pay and productivity pay commissions to the finance department, Your Lordship. This was the instructions I have received yesterday, Your Lordship.
So, it's under consideration.
They said they have,
Indirectly,
this
yes,
is
Your
what they
Lordship.
said has come today, my lord. So we'll, I don't know what actually it contains, my lord, whether it confirms to our prayers and my lord. whether-
And Lordship, this is yet to go to the finance department. Lordship will go through the second.
Proposal to পঠাইছো।
Second paragraph, second last paragraph, sentence.
Subsequent departmental affairs are the director of secondary education furnish so information. So it's not up to the finance.
Yes.
It's within the department itself.
Yes.
It's within the department, not to the finance.
So,
So some more time, your lordship.
Lord Mr. M. Datta, learned counsel for the petitioner. As in terms of the order dated 22/10/2025. No, MS
Terang P, lordship.
Esther learned standing counsel,
Secondary education, your lordship.
secondary education. By placing the communication dated 04/02/2026 submits that the grievance of the petitioner is being under consideration
Oh, what's up, Pune Memon?
and the necessary steps should be taken within a period of 3 weeks. Necessary steps would be taken within a period of 6 weeks to place the matter before the finance department. Therefore, first for listing of the matter after 3 weeks. Whereas allowed list the matter after 3 weeks. In the meantime, respondent authorities, including the finance department.
all this is a development. Once the proposal.
Would consider would consider and decide the matter expeditiously.
Deplorable, your lordship.
Lordship, this matter relates to non-payment of DCRG, Lordship. The petition is the minor daughter of the deceased, Lordship. Application made before the department, Lordship. Till date, no money has been provided, Lordship.
Madam, I am appealing for response number 2 and 3, Madam.
Ah.
Let him submit me a copy of the petition, Madam.
Up to 24, no copy has been served. Mr.
S. Sutradhar, Lordship.
Huh?
S. Sutradhar, Lordship.
S. Sutradhar, then counsel for the petitioner to furnish a copy of the writ petition to Mr. S.P. Das. Then standing counsel for respondent number 2 and 3 within 2 days. 3 weeks.
Lordship, we need 3 weeks time to file a rejoinder affidavit.
On the prayer of.
No matter stay since to 2024.
Okay.
This court, while admitting, issuing notice and putting the order to stay, gave liberty to us, transfer him somewhere else where medical. Now he's been transferred to Daporijo, which is a district headquarter, Lordship. All the medical facilities are available, Lordship.
Oh,
No, sir, we need 3 weeks time.
what 3 weeks?
We filed affidavit in Lordship. December 24.
24, 2024. 1 week. Affidavit 1 week. All right. We'll take it up, dispose, transfer matter. From where to where?
From Guwahati to Yongkyong.
Yongkyong.
He approached this court, stay was put to it, giving us liberty to put him somewhere else, Lordship. Now we have issued an order.
Yongkyong and Dapur is almost same place.
Lordship.
Yongkyong is also district headquarters.
Most of
It's a district headquarter of Upper Siang. And Dapur is district headquarters of Upper Subansiri. Same.
And not his ailment, not can you look into ailment. Page 58. Hypertension, obesity, diabetes. It's a common to all.
So you are not challenging where is the order?
You,
No, on what basis you have transferred him?
he was here for more than 3 years. Others
No, no.
are waiting for years.
No, you
Now
said-
he's almost 5 years.
No, you said there was a liberty granted to you.
10, 4, 10, 20, 30.
Okay, by taking provisional rules as well as the standards, this court has passed order in granting time to release for sick and check. Yankyang, the prisoner can be posted Pasigat or any other which has the requisite medical. Today, when the matter is called, on transfer, the prisoner can be posted Pasigat for another person. If it may be.
Lordship may fix a date. Let them, they want to file a rejoinder, but Lordship may fix a date, Lordship. Otherwise, out of 30 years of service, 26 years he was in soft posting, Lordship. Only 4 years in hard posting, Lordship.
What is his post?
Section officer. It's an office job, Lordship. Nothing to do with labors and all.
Madam,
Yes, my lord.
you be away from hustle and bustle. What is a very crowded place? Therefore, is a beautiful, yes, beautiful place.
Lordship,
You will have lots of experience, different kind of, including the food.
yes, my lord. Grant me 1 week's time for rejoinder affidavit.
There's nothing in fact. Anyway, what to do? On the prayer of Miss MS
S. Borpujari.
S. Borpujari, a week's time is granted to file affidavit in reply. Mr. B. Chakraborty, learned CGC is present. Next paragraph. Considering the nature of the considering the matter which pertains to transfer and posting, and the petitioner having been transferred other than the transferred into other the transfer to Daporijo during the pendency of this is permitted by this court, as allowed by this court, which is a new place. Lead place, let this matter be listed after a week. It is made clear that no further adjournment shall be granted on the next day. Give the date. Transfer process. He's still here. He's still in Guwahati.
But more than about 5 years. Others are waiting for this posting.
We'll dispose it next week. Yes, madam.
Chip, this is an application for granting family pension to the husband of the deceased. Granting of family pension.
Family pension.
Family pension.
Yes, we
The
spoke.
NPS scheme 2005 to the deceased, to the husband of the deceased. The deceased was a lecturer in the Assam Satriya Sangeet Mahavidyalaya, Rajabari, Jorhat. Lordship, she had been working there since 1999, but in 2021, the government of Assam was pleased to include the said college under the cultural department of Assam, and she had to join her service after that notification, but she was suffering from cervical cancer at the time. So her joining was late, and she joined in the month of September 2021. And after her death, when her husband applied for the pension, the respondent authorities rejected his claim by saying that she didn't complete 1 year of continuous service, which is needed as per the NPS scheme 2005.
My lord, I am appearing for the cultural department, but it is respondent number 6, we have to take a call.
Which is respondent number 6? Who is respondent number 6? Who is respondent? Principal? Yes, notice has been served. Anybody appearing for him?
Wakalatnama
Any response?
Wakalatnama was filed. I saw one name called ML Pandya.
L. Pandya.
ML Pandya. Respondent number 6. Who has to consider? Respondent number 6 or you, including you, Mr. Dar.
My lord, also have something there, my lord, but we are yet to file any affidavit, my lord, here.
You file it?
My lord.
Yes, Miss MS so and so, learn counsel for the petitioner. Mr. Learned, the respondents. Respondents are granted for the 3 weeks times to file response. List them after 3 weeks.
Hello, please.
43.
Case for regulation service and salary mill. They took time on the last occasion when notices were issued
Yes,
on 25/6, Milord.
you are supposed to file additional affidavit, sir. Have you filed?
No, nothing has been filed.
No, you
No,
said learned competitioner matter stands to enable her to file an additional affidavit, bring on record certain materials which are relevant to the case as permitted. You are supposed to file some additional affidavit.
Last order. Last order. Actually.
In which post?
teachers, Milord.
Teachers. 1992, 2001.
Yes,
You
Milord.
are still working.
Yes, Milord.
Have you not attended as of superannuation?
No. They were scrutinized at different times, Milord, for regulation.
Yes, madam. Are you for the respondents?
My lord, for
Who has to respond?
They have to respond, Milord.
BTC.
Yes.
Then why you are keeping quiet?
Meeting instructions and also.
Say so.
Lordship,
Submit
on the
that.
last occasion, they have taken time for providing
It's
additional.
okay, it's up to them.
Lordship.
If they don't want to file, you cannot force them. Whatever they have filed, at least you respond.
Yes.
Or Mr. Chalia, DP Chalia, Learned Senior Counsel, assisted by
And right.
petitioners.
B. Bora for BTC man.
P. Bora, MSP Bora, Learned Standing Counsel BTC is granted for the 3 weeks time to file affidavit. List after 3 weeks.
445.
May I please, Your Lordship?
Yes.
My lord, petitioners before your lordship is a state government employee, my lord. State Bank of India's my lord manager, my lord. He was suspended, my lord, long back, my lord. Thereafter, my lord,
State government employee?
State Bank of India's employee.
Yes.
And suspended long back, my lord. But as per, my lord, their departmental rule also, my lord, without review quarterly, suspension cannot be continued.
Ha.
They are not reviewed, my lord. Then, my lord, Ajay Kumar Chaudhary, Honorable Supreme Court also guided that, my lord. After, my lord, 3 months cannot be continued if it is not reviewed. Therefore, we are before your lordship, my lord.
So how long you have been under suspension?
Yes.
How long?
No, my lord. He is from, my lord, 9/5/2025, my lord. 9/5/2025. More than 6-7 months, my lord. Page, my lord, 161 is the suspension order.
161.
61.
Why so many writ petition? Why two writ petition?
Two by 2%, my lord.
2%.
On the same day, my lord, suspended.
Same order,
No, my lord, separate.
different. Where is page?
Page 161, my lord.
Hmm. In view of it has been decided not to.
My lord, relevant portion, my lord, page 162, my lord, third paragraph.
Of the bank holiday were
comparative-
placed under suspension with immediate effect in terms of measure of a copy of the order is enclosed during the period of the suspension. Yes.
Yeah, my lord, and my lord, I have, my lord, annexed their rule, my lord. It is, my lord.
Have you filed the appeal?
Yes, my lord, appeal is also pending, my lord.
Huh?
Appeal is also pending.
You have filed the appeal?
Yes, sir.
Yes, what happened?
In this case, the petitioners were submitted charge sheet, your lordship. Charge sheet were given to them, and disciplinary proceeding is going on, your lordship.
Have you reviewed?
Yes, your lordship. It was after beyond the period of 90 days, your lordship. However, the Honorable Apex Court judgment, your lordship, it clearly covers that once the charge sheet is submitted, your lordship, the directions of review does not apply. So in that case, they may participate in the proceeding, disciplinary proceeding, and if they are agree with the outcome of the proceeding, at any point of time, they may approach this Honorable Court challenging the proceeding. So right now, the proceedings are going on. So they are also taking part in the proceedings also.
Law is clear, my lord. I have submitted also some judgment annexing with my affidavit, my lord. That, my lord, if it is not.
Charge sheet has all been filed.
Charge sheet filed, my lord. but-
Memo of charges has been furnished to you.
Yes, my lord. But it is after, my lord, 3 months, my lord.
Huh?
After 3 months.
Where is the requirement review of 3 months?
Yes, my lord. Lordship, kindly have a look. I have annexed one judgment.
Not judgment. The rule.
Yes, my lord. Rule, my lord, it is in here. Rule, lordship. Page.
What
my
the
lord-
requirement of review?
Yes, my lord. Page, my lord, 351, my lord.
351,
my lord. Running page 351.
Business manual.
Yes, my lord. And the relevant portion, my lord, 352, my lord.
In order to ensure that the period of
My lord,
suspension is kept
3.2,
within
my lord.
jurisdiction
Page
of
52, my lord. Periodical review of cases of suspension. 3.2. 3.2, my lord. A review of the case at quarterly interval shall be made.
Has it been done quarterly?
No, my lord.
Review was done on 13/10/2025.
No, my lord. No review was done.
No,
Lordship,
review is done.
in our
Lordship, kindly have a look. They are referring one review. It is not by any means. It is not a review, my lord. But they are claiming that, my lord, it is review in their affidavit. Lordship, kindly have a look.
Show us.
291.
291.
Lordship.
Old one or new one?
Annexure 7. Annexure 2.
Annexure 2.
Lordship.
There is 335. 335.
Discrepancy in the period.
Earlier 291.
Lordship.
It is 335 now.
In my affidavit,
Here, your lordship.
Place alongside is listed list of Basmation cases of vascular and awards for this.
in my affidavit also, there it
We
is there.
request the circle management committee to offer comments if any to enable us to advise the corporate center. Then
Mentioned in serial number 9 and 10.
where is this review?
No one.
You read the contents.
Yes, ma'am. It is proposal to, my lord, to consider review. Nothing was done.
Your lordship.
Are you comfortable in Hindi?
Review of
It is English along with.
review of suspension.
Are you comfortable in Hindi?
लॉर्डशिप
You read in Hindi.
यस लॉर्डशिप 30 सितंबर को समाप्त तिमाही के लिए सर्कल पर्यवेक्षण और अवार्ड स्टाफ के निलंबित मामलों सूची साथ में रखी गई है. Placed alongside is the list of suspension cases of the circle supervising
and award staff for the quarter ended 30th September 2025.
Yes, then
Then हम सर्कल प्रबंधन समिति
say
अनुरोध करते हैं कि यदि कोई टिप्पणी है तो हम तदनुसार कॉर्पोरेट केंद्र को सलाह दे सके. We request the circle management committee to offer comments.
Yes.
Your Lordship,
it's not a review.
Your
You are
Lordship,
seeking some advice
yes, your review is done.
by
if any-
placing this person under suspension so that you can advise the corporate office.
Yes, these persons suspension order has been placed under review and comments are sought from the higher authorities if any comments has to be passed regarding the review of these persons.
So it's not a review. It's not a review. You're seeking, these are the persons who have been placed under suspension. Therefore, you are seeking some information. I mean, seeking some comments. And to offer comments so that you can advise to the corporate office or corporate center. That is what this says.
And even then, your
If I understand the English and Hindi,
Lordship.
it's not a review.
Yep. In my humble submission, your
Not
Lordship,
done, man. It's covered case.
charge sheet has been already been submitted, so they may
After
take part.
3 months. After March, later than 3 months.
Hmm?
Charge sheet was subsequently submitted, my lord, after 5-6 months. My lord.
Disciplinary proceeding is going on, so they can participate in the
You
proceeding.
could say that, my lord, let them work, my lord, because they are otherwise fading away, my lord. So they may be transferred otherwise.
There's
but-
no review as such, and I know there are, even after the charge sheet, you will have to review again.
Review, my lord.
Certain, I don't know what is the procedure. It's just
Nothing done.
quarterly. So you obtain instruction, better to revoke the suspension, let them participate in the this thing.
And there may be, liberty may be given, they may transfer other state or other place, my lord.
To obtain obtain instruction next week.
No, no.
Next week. Next week.
Kindly, my lord, any date may be fixed, my lord.
Then 2 weeks. After 2 weeks.
My lord,
Any day.
kindly, madam.
That Mr.
AM Borbia, my lord.
A.M. Burboyal and Council for the Petitioners.
Since long time, my lord.
Ah,
out of service.
2025. Writ petition is 2025.
My lord, out of service, my lord, they are
Uh,
regular
consider-
employee out of service, my lord, they are feeling
Having
anxiety,
considered,
my lord.
having considered that, no, it appears that no review has been taken, taken.
Till date.
No review has, it appears that there is no review undertaken by the authorities
Till date.
as regards the suspension of the petitioners
Till date, my lord.
list of considering about the learned counsel for the petitioner,
State Bank, my lord.
State Bank,
Malad.
sorry, to obtain instruction.
Next Tuesday,
List
my lord.
after two
My lord,
weeks.
find any date, my lord, next Tuesday, my lord, please.
Then in-
Small, my lord, matter, my lord.
In that case, after 3 weeks, give the list, give the date.
My lord, they are, my lord, out of service, the anxiety is, my lord, they are.
Out of service, you're in under suspension.
Yes, my lord.
2nd March.
My lord, it is too late, my lord. Small, my lord, issue, my lord, lordship should verify.
It's a big issue.
Any shorter date, kind, my lord. February, any date, my lord, kind.
2nd of March, 2026.
So here the state is required to file their affidavit. That
Lordship,
What is the issue?
appointment of Gaon Pradhan.
What's wrong?
You
You want that you should be appointed as Gaon
He
Pradhan.
is not a native, one person is selected who is not a native of the
Yes.
place. Madam.
Lordship, my lord,
What is the requirements? Person should, candidate should be a native of that.
Native of that place, Malad. In here, the person, one person was selected.
Lot. Provide of the advertisement was made.
Not necessarily a native. What do you mean by that lot?
Lot, my lord, that particular lot, it is maybe by law that 2 village, 3 village, or my lord, that the lot has been constituted by the revenue.
So then instruction, what's there? There's simple claim is that you have appointed a person who is not from that village.
My lord, that is
So
their
if-
claim, my lord, whether.
If you for that you obtain the instruction whether his claim is correct or not,
But
it's
there
very
is a
simple.
Statutory provision, lordship, page 37, the appeal provision is there. Against the 162C, my lord, they can prefer an appeal, lordship.
In fact, Malad, earlier the petitioner approached this honorable court. This honorable court, Malad,
Okay, where is that? Page
37. 162C, lordship.
60,
Executive instruction,
once, page 37.
37.
An appeal against the order of appointment, suspension and dismissal of Gabura by the disposition cell. What is this? Gabura.
Now, my lord, it is a reason, my lord, as a now.
Shall lie to the divisional commissioner within a period of 60 days from the date on which the appeal received the copy.
then your losses, one aspect of the matter, Malad, can it be on Tuesday next? So
Why?
final disposal, they not like to file affidavit most probably. I will prepare myself, Malad, I will satisfy your losses. There is a hearing day on Tuesday
No,
next
no.
month.
You said, did you file any appeal?
Well, in fact, earlier we approached this honorable court. This honorable
Okay,
court
earlier is
directed-
over. What they said?
This honorable court directed to investigate matter. Malad, page 68, the order passed, Malad.
No, thereafter what happened?
Thereafter, they investigated the matter, but it has not come to a conclusion. That is why we approached.
It's not concluded,
Malad,
or it is concluded against you.
Malad.
Has it been concluded? Any finding?
The find, we set.
Which order you are challenging?
We are challenging this order, Malad, page, Malad. I'm coming, Malad.
In the pair lordship, they are seeking direction to appoint a petitioner. The point, so 152, 153 has to be complained of.
My humble prayer for your lordships, can it be on Tuesday? I could not prepare, in fact, the matter today. That
My
is why-
request, the request of this court is let us know which order you are challenging. That effort they have pointed out, there is an appeal provision. Why don't you avail that?
That is why I'll satisfy your lordship on Tuesday.
You satisfied now?
Malad.
Why you have no, why you cannot file appeal, or is it an
I'm handicapped because I was led by one junior. She is not come. Just now I have the brief. That is why.
junior is not coming and senior is coming? What sort of, practice is this? Who is your junior? You reprimand,
Name is reflected.
You
A. Talukdar.
you
No,
reprimand him.
she was not there. That is why, due to some personal difficulties, she could not come. And that is why I could not even prepare. I expected that she will do this. Malad.
A. Talukdar.
Malad. Tuesday, I'll
No,
satisfy your lordship.
I'll just show you, come to page 37. This is an executive instruction,
Malad.
of course. An appeal shall lie against the order of appointment, suspension, dismissal of a Gabura by the deputy commissioner. You are against the, agree by the appointment of the private respondent.
Malad. let the matter be on Tuesday so that I could satisfy your lordships, because I am also not, just now I handed over.
Suppose if there is a provision appeal,
Your lordships,
can you bypass that?
definitely not.
Huh.
Definitely not. But since Malad, they earlier also approached this honorable court directed to investigate the matter.
That
And
has been,
it is
that
not
has been,
confluent
that has
conclusion.
been, that has been investigated.
Not even, that is why I try to find out the Malad. Well, page 492, Annex R. There is a communication to me from the DC office, Malad. It is not conclusive. That is why we again have to approach this honorable court, Malad.
According to,
Why
this is not conclusive?
Some physical inquiry was conducted and report is submitted.
So many hearing, nothing. Respond number Jalauddin Shoaib Ali has also submitted 14 of Biko LAC voter list on more than documentary evidence submitted mentioned regarding illegal football of them and attached copy.
In conclusive, page 98,
No
observation is
substantive
given.
documentary evidence could be probably Ibrahim Ali. You are Ibrahim Ali.
Ibrahim Ali. Page
Which can
98, the
justify that
observation
he
is
did not
against me,
receive
Malad.
additional marks.
It is not conclusive. That is why we have to approach this honorable court again, Malad. So I'll satisfy on Tuesday, Malad, the
Who has conducted this inquiry?
solely the DC office, Malad, instructed one of the executive magistrate, Malad.
Heard Mr. UK
Malad.
Goswami, learned counsel for the petitioner. On the prayer of Mr. J. Hending, learned state counsel, let this matter be listed after 2 weeks so as to enable him to obtain instruction. List of, since Mr. Hending, learned state counsel raises the issue of maintainability of the writ principle, same shall be considered on the next date. List after 3 weeks.
2 weeks, Malad.
2 weeks, huh? Nah.
Hello.
May I please, your lords? Matter relates to February bench, my lord. My lords, may I go through the earlier order, my first order, previous order, 7-1 order, my lord.
7-1.
7-1, 2020.
Petitioner furnished
My petitioner before lordship is the first wife, my lord. Husband died, my lord.
Any response?
On the other hand, my lord, both side, both wife and both stakeholder has already been heard by the inspector of schools pursuant to letter issued by the director of pension, my lord. Matter is now pending before the director of pension. So your lordship, in the light of the inquiry report submitted by the inspector of schools, your lordship also dispose of that both methods. As because both parties has been heard.
Our lordship, they have filed their affidavit in reply in our case 60, item number 60. I am going to file reply, lordship. They kindly list the matter after 2 weeks.
Heard Mr. So-and-so learned counsel for the petitioner. On the prayer of Mr.
MK New.
MK
Item number
New,
50.
learned counsel for the petitioner in WPC 2528.
2528, lordship.
2025. 2 weeks time is granted to file affidavit in reply to the affidavit of opposition filed by affidavit of opposition filed by the
Filed by the item number 6, filed by respondent number 6, lordship.
respondent number 6. MS so-and-so. You have also filed.
Not necessary, I think, your lordship, because
Why? You have to, director has to decide.
obtain that instruction.
What is saying that as per the inquiry report, the
Already
director
inquiry
has
has-
to take a call. You are the one who has to take a decision.
With regard to service of notice of response, my friend already appeared, my lord. So I am serving him copy today itself, my lord. In item number 59,
MS.
notice of response.
Will be listed on this note. You are appearing for the prime respondent.
Yes, lordship.
2559. Then you read MS therapy so and so.
1 and 3, 3 and 5.
Mr. In the land council for the petitioner in writ petition, 2559/2025.
Yes.
No, you right? Mr. So and so, new land council enters appearance on behalf of respondent number 7 in WPC 2559/2025.
Date may be given, my lord. Family venture.
Therapy to obtain instruction, also.
Date may be given.
After 2 weeks.
Value.
May I please, Lordship? In this case, a little modification is required, Your Lordship. What happened, Your Lordship? During the pendency of the MSc appeal, 13,64,000 was deposited before the registry.
Yes.
And the total amount was 20 lakhs. Total amount was 20 lakhs, Your Lordship. Out of that, 6,35,000 was
To be deposited.
Yes, deposited. So Your Lordship was directed only to release that amount only, the 6,34,000, and the direction regarding 13 lakhs is not given, Your Lordship.
What about, what will be the,
Your Lordship.
what would be the share in 13 lakhs?
60/40 amount, Your Lordship. Claimant number 1 will get overall 12 lakhs. Claimant number will get 12 lakhs out of 20 lakhs. And claimant number 2 will get 8 lakhs, Your Lordship. As the whole, if Your Lordship give the order like that, out of 20 lakhs. Claimant,
Have you received already?
not received. This is pending before this Lordship. Registry, all amount, Your Lordship.
Whole amount.
All amount, Your Lordship.
Then we'll just clarify that the total amount.
12 lakhs, yeah, 20 lakhs, Your
So
Lordship.
the total amount of 20 lakhs
Yes,
deposited by insurance
yes,
shall be released
yes, Your Lordship.
to the claimants,
Claimants,
both the claimants,
claimants.
which who shall have the share of what is it called?
60 and 40%.
60/40 ratio.
That is, Your Lordship.
That will say.
Yes,
Not
Your Lordship,
Mr.
direction, Your Lordship, that 8 lakhs to the claimant number 1.
No, will not say that. 60/40, that is you have decided.
Yes, Your Lordship.
Is it so?
60/40, Your Lordship.
You are
Claimant-
for claimant,
Claimant,
both the claimant.
both the claimant.
Not Mr. So-and-so, then counsel for the petitioner, land counsel for the applicant. List of decision application. Where's the respondent?
Respondent, Your Lordship,
Oriental Insurance.
they have already deposited the amount, Your Lordship.
No, sorry. Applicant oblique claimants, huh? List of, next para, this is an application seeking modification oblique clarification of the order dated 13/12/2025. Passed in MSc appeal number 470/2025. In the National Lok Adalat.
Look at that, Your Lordship.
National,
Yes,
National Lok Adalat.
dated 13/12, Your Lordship.
List of,
Your Lordship, if Your Lordship will give 60/40, then they will give, again, registry will say that, take the specific amount, Your Lordship.
how do you, 60/40, how much it comes?
12 lakhs and 8 lakhs, Your Lordship.
It is, no, it is noticed that no, in view of the settlement. For payment of
20 lakhs, Your Lordship.
sum of rupees 20 lakhs, out of which rupees 13 lakh 64,000 having been already deposited, comma, it has been directed to deposit remaining remaining amount of rupees 6 lakhs 36,000 as a full and final settlement of the claim list of. Next, however, inadvertently, it appears that inadvertently the this court has directed that the claimant number 1 shall be entitled to receive 3,81,600 and the claimant number 2 shall be entitled to a sum of rupees 2,52,400 out of 6,36,000 without indicating the amount of rupees 13,64,000 which was already deposited by the insurance company before the registry of this court. Listen. Accordingly. No. In view of above, it is provided that the claimant number 1, namely Hafiza Begum, shall be entitled to withdraw, entitled to 60% of the total amount of
20 lakhs.
20 lakhs.
That is
And
12
the
lakhs.
claimant number 2, namely Husna Begum, alias Husnara Begum, shall be entitled to receive 40%.
40%.
By a 60:4 ratio. Accordingly, it is permitted. According the applicants, both are there.
Your Lordship?
Both are there
Yes, Your Lordship.
in this application.
Yes.
Accordingly, applicants, public claimants are permitted to withdraw their respective shares of the amount as indicated above out of by a 60-40 ratio, i.e. minus it includes your statutory deposit.
No. It was directed to release the 25%, Your Lordship.
It's okay. 25% is
25,000.
that is
Different.
different, huh?
Yes. Not from the
By way
amount.
of 60-40%, 60:40%, 60:40 ratio. I.e., what is the amount?
12 lakhs for claimant number 1.
Only 12 lakh.
12 lakhs and 8 lakhs for claimant number 2. 8-2.
This IA stands disposed of. This order shall be a part of the order dated 13/12/2025.
Your Lordship, last para maybe this accordingly that maybe registry maybe that portion, Your Lordship, in page number 4, Your Lordship, last para. Page number of the order copy, Your Lordship.
Yes, you have permitted to
Yes,
withdraw, that's all.
Much obliged.
Fine.
Then the correct address of respondent number 5, Your Lordship. correct address to them. Lordship, I'll provide the address to them, the correct address of respondent number 5, your lordship.
To him.
My lord, the last order dated 1st December 2025, the respondents were permitted to obtain the correct address of respondent number 5. They have obtained the address, proper address right now, and they wanted to.
So you are going to punish him? Punish? The MS
On behalf of.
Burman Learned Council appearing on behalf of MS Egg and NSCG submits that he would be furnishing the proper and correct address of respondent number 5 to the Learned Council for the petitioner, Mr.
DC Kalita.
DC Kalita,
DC Kalita.
during the course of the day for necessary steps. List after, then you'll have to take steps.
We have to take steps within 5 days or 6 days.
Then you have to file application for change of correction of the address. Thereafter, the Learned Council for the petitioners on receipt of such correct and proper address of respondent number 5. And Council for the petitioners should take steps. Steps including filing of affidavit, everything. And
Change of the cost title also.
You file an application for correction and we'll correct it, and then you take the steps. That's all. Yes, next.
7.
Yes. Yes, Chakraborty.
Stated against respondent number 8, 19, 21, 27, and 32. Lordship will peruse the last order. Since last 2 years, they have been seeking time to obtain instructions.
What to do? Let's just see. Non appears for the prisoner on call, Mr. Learned.
For some of the respondents, private respondents.
Learned Council for the respondents. 1 and 2 and so, and Council for respondents are present. List after 4 weeks. Make it 3 weeks.
May I please, your lordship? Lordship, as per office note 29/1/2026, my lord, the service report is awaited. Steps have been complete.
You're supposed to file amended post title by correcting the name of respondent number 4.
You have filed, man. Name correction, man.
It was permitted in November.
Respondent number 4, man.
Service of respondent number 4 is still,
Huh?
service of respondent number 4 is still awaited. I
No,
think.
he has not filed any amended codes
No copy.
on the prayer of, no, Mr.
Yes, Ahmed.
Learned Council for the petitioner is granted a week's time to file amended course title by correcting, no, it's directed to make necessary correction in respect of the name of respondent number 4 by filing amended course title. List after a week, we'll see.
Nice.
Wait, please, Your Lordship. My lord will kindly peruse the office note dated 21/8, my lord. My lord, we had filed one IA for deletion of name of some of the petitioners. That was allowed. Then we were directed to file one amended cost title. That we have also filed it.
It's been done.
Yes, that is why this on my matter has come up for orders, my lord.
Yes, so
Now, my lord, in the main case, my lord, the state has yet to file their affidavit in opposition. So
3 weeks may be given, but I'll file affidavit. I have received the instruction.
you file already, it's been done.
my lord, it's done.
Or Mr. So-and-so, learned counsel for the petition. On the prayer of Mr. S. Dasland, standing counsel, our education department. For the 3 weeks time is granted to file affidavit.
I'm deeply aware.
May I please, Your Lordship? In item number 52, the standing council BTC was supposed to file affidavit, Lordship. In 54, they have filed it, Lordship. Only in 52, my lord, we have not received instruction, my lord.
Heard MS
In
so-and-so,
53, 54 and 55, we have filed our affidavit.
you have already filed.
Lordship, filed. Only in 52, item number 52, ma'am.
It is submitted that submitted by Mr. S. Bora, learned standing counsel, P. Bora, learned standing counsel, BTC. And affidavits have been filed. Affidavits has been filed. Affidavits have been filed except WPC 4842 of 2024, for which she prays for and is granted for the 3 weeks time to file affidavit in WPC 4842 of 2024. List after 3 weeks.